Justice Modiba's question.
Yes.
So on that first item, we are going to argue that you should strike the application to compel. It's not properly before you. But Mr. Mpofu takes a different view, so that we didn't want to resolve that. He must do what he wants to do, but we will ask you to strike it.
I confirm that.
Thank you. Are we ready to start?
Yes, we are. It's now 11:35. Thank you, my lords and my lady. As agreed and confirmed now with my learned friend, the discussion in chambers, the first question I have to deal with is the status, shall we call it, of the application to compel. Where's that letter? You will, if you look at, we have filed separate heads for the application to compel, which your lordships what we filed on Friday were three documents: the joint practice note, the heads on the compelling application, and then the heads in the main application. And the current one we're dealing with is at 055-54. Those are the heads, first applicant's heads of argument in the interlocutory application to compel terms of Rule 53(1)(b). So before I get into those heads, then let me address that to the preliminary question. You will recall, well, the ADJP maybe more than anyone else, will recall that on the 26th February 2026, the parties wrote a joint letter to you, ADJP, I don't think it's on the case. I'm sorry, I had asked for 10 copies to be made, but yeah, I'm sure the ADJP will take my word for it for now. I promise that it will be handed up at some stage.
10 copies of what?
Of the letter to the ADJP. Yeah. So that letter said the purpose of this letter is to communicate the joint and agreed position of the parties as to the further conduct of this matter, given its nature and the volume of papers so far. The matter involves the relatively complex and sensitive matter concerning the recusal of former Justice of Constitutional Court as Commissioner and Chairperson of the Commission, in which other commissioners are a former judge and senior counsel. Then number 3, which is where I'm going, said, to date, the matter entails 3.1, the application for urgency and condonation in terms of Rule 612, which has since fallen away, nobody's taking urgency. 3.2, this is the important one, the main application for declaratory and or review relief, and 3.3, which is what we're now dealing with, the application's interlocutory application to compel better and further discovery in terms of Rule 53(1)(b), which is opposed by the 1st to 5th respondents. And then other things about security, which asking for security, that's also been withdrawn since. And then so did the letter go. So when the parties, all these parties were asking you to allocate this matter for 2 days, the reasons were those items, that there will be an application to compel and various other things. Now, so that was the basis on which the parties jointly agreed would be the set down. And kindly the ADJP agreed with the proposal of the 2 days as requested. Then if we go to the 004-21, I think. Sorry, Justice. Okay, I've got it here. Remember, the allegation is that the matter is not set down or is not before you.
Can I make the following practical suggestion?
Yes.
Any one of the colleagues be invited on case lines so that is paid. If they can.
Yes,
Including
I'm sure
your
one of
instructions.
these many people will be able to do that.
Yes, somebody's done so, and for that,
Yes,
thank you.
that will assist. Thank you very much, Justice. But I'm now taking the court to 004-21.
Just one moment.
So, oh, what-
Just approve the bench, please. That's Assistant Brother you choose.
I was going to ask for water.
Here we are. Thank you.
The attorney is off today. Thank you. Yes, my learned, one of my learned friends says they have done so, but there might be a problem with the internet. I'm sure it will be sorted out between.
No, we are invited.
You are invited, escort places. Thank you. Right. So, it says then take notice that the applicant will apply on a date to be allocated by the Honorable Judge President, supposedly acting Deputy Judge President, or the registrar, alternatively at the hearing, which is today, for an order, and then I won't read out the orders. And then take further notice that the supplementary founding affidavit of Jacob Gedehlegisa Zuma, annexed here due, will be used in support of this interlocutory application. That is what is known as Form 2A, which is the form that you do in terms of Rule 611. Rule 611 is the rule that deals with interlocutory applications. So you set it down in Form 2A. In other words, the long form, the so-called long form and short form. In the long form, you then say you must file on this and that and that date. In the short form, you don't do that. There's authority to that proposition. And there's further authority that the respondent then has a duty to do two things. File an answering affidavit within a reasonable time, and so on and so on. So this was then met with basically a relative silence. I'm sorry. And we raised this issue at, you'll go, if you go to 004-36, I'm sorry. You will see where the narrative of the application is given. The heading says interlocutory application to compel. 004-36. And then you see paragraph 13, 14, 15, 16, 17, 18, 19, 20, 20, 21. That's the application to compel, right? No answering affidavit to that application. And the only thing that you will find is in the answering affidavit, literally, there's one line which you will find, sorry, at paragraph 209 of the answering affidavit.
Who's answering it?
I'm sorry, of the main answering affidavit of the commission. Sorry, Justice. So if you go to 015-52,
Still with us? Can you write us as you were saying?
thank you. 015-52, at paragraph 209. We say in our heads, if one wants to be generous, you can say that's the only paragraph that indicates any qualms with the application to compel. It simply says, so when it says add paragraph 10 to 22, those are the paragraphs I just referred you to. That's the application to compel. And the only thing that is said is, I deny this allegation. There is in the first instance been no improper withholding of the record.
Mr. Mbeki, we have not been directed.
Oh, I'm sorry. Yes, 015-52. Yes. Is it there? Thank you. Thank you, my lady. So you see, for all that long application, you get 207 to 209. So that's the only ever under the sun comment that is made about that long application. One says, I deny the allegations. 2, there's in the first place been no improper withholding of the record. 3, President Zuma is not at liberty simply to make unfounded allegations on the basis that a reverse onus will then be imposed upon the respondent to divulge private communications, which is interesting, notwithstanding the absence of any truth or substance to these allegations. That's all. And we say that that's not even opposition. Remember, what we would have expected is an answering affidavit to the interlocutory application, because it has a life of its own. It's a separate application. At worst, it would be in the answering affidavit, but that's all you have. Then, so we do our reply, Justices, which you will find at 017-2. And again, as if that's not enough, despite the non-response, we reiterate. You'll see A2 at 017-9 is headed application to compel, just in case maybe people didn't notice it yet. And we say it is anticipated that the Rule 53(1)B application to compel will be entertained up front, but together with the main application, it clearly has, that's why we said at the hearing, it clearly has a bearing on the merits as the record, as the, of the second ground for recusal based on the actual and or reasonably perceived bias, as well as the separate but interrelated accusations of judicial misconduct or potential criminal charges for corruption in terms of Section 8 of PECA. And so in addition to what is stated, says Mr. Zuma, in my first supplementary affidavit, I reiterate that the application to compel is deeply anchored in the fact that the existence of the documents which have not been disclosed is not in dispute. What is in dispute is their alleged impropriety. Then it goes on and on. But I'll just read paragraph 30, which is important for this leg of the thing. You say, most, that's on 01711. And it says, most notably, and rather curiously, save for the meaningless and bare denial found at paragraph 207 to 209 of the affidavit of Semenya SC, there is no defense advanced against my detailed and well-motivated application to compel. Nothing therefore stands in the way of its granting. In the circumstances, the application to compel must be upheld with punitive costs. So, what am I saying? We have a situation where a party in terms of Rule 611, files a notice, nothing is done, except for that one paragraph, which, with respect, we can ignore. It doesn't say we're opposing, it just says we don't agree with what you're saying. We remind them again in the affidavit, replying affidavit, you have not addressed the application to compel. Nothing is done. Then we send this court, by agreement, a practice note on Friday, which lists among the issues that have to be discussed the application to compel. In your practice note, you'll see that we even go as far as to say you'll find that it's 029-7. Go to 4.2, that's at 029-12. This is now the joint practice note of all the parties. In respect of the former President Zuma's application to compel, he contends that this application must be determined upfront. The notice of motion did not contemplate any delivery date of the supplemented record as requested, and the Commission has not delivered the same. In other words, was telling the court that that was asked for has not been delivered. In other words, the application is still ripe. The first applicant will therefore file separate heads of argument dealing specifically with the interlocutory application, we tell the court. And if you go to 4.4 again, all the parties sitting here say to the court, in respect of the main application, the applicants have raised the following preliminary legal issues. Then we list those issues, and then we say, one is the application to compel, which we've said should be done up front. Application to be recognized as co-applicant, which has now been settled. Status of the answering affidavit in the proceedings before the commission of the chairperson. Non-opposition of the order for termination by the president. The nullity of the impugned decisions, and so on. The point I'm simply making is that in this, it's made abundantly clear in the practice note that the application to compel will be done up front. The last point I want to make in this respect is to take the court to, oh no, I've already taken the court to the notice of application. Yeah. So that's, I don't understand how an application like that, which has been properly set down, to be heard up front at the hearing, yes, and where reminders have been given galore, maybe 5 or 6, to say what are you doing about it, and even a forewarning that there'll be separate heads, and those heads were filed. Nobody has returned files, other heads against it. How that can be said not to be before this court. And the last thing I want to say is that there was not even a need to keep on repeating the obvious, that application has to be discussed up front. Obviously, firstly, by definition, this thing called interlocutory application means it's interlocutory to the main application. But secondly, in the case of this particular application, which is almost like a Rule 35 thing, it's an application to compel discovery. So I've never heard of a situation where you ask for an application to compel discovery, and then you are told, no, you must do it after the trial. The whole scheme of Rule 53, Justices, is that it is designed for this. It's the only rule that's designed for this. You do your founding affidavit, you await the record. When the record comes, without having to do an application in terms of Rule 65E, you automatically have a right to supplement. Why? Because that record is supposed to give you the information. The authorities are in our heads, FUL, the DA case, and so on. It's supposed to, you're supposed to be given that information so that you can then supplement. Only then, unlike the normal situation in Rule 6, only then is the respondent supposed to answer. Because there's no point in them answering to that first thing, because it's a half, it's not the full application. And then they only answer after that. Now, in this particular case, it's even more. It's unfathomable how the rest of the application can continue without this question, because the information we seek, and I deliberately didn't read it out, is really, in essence, the alleged email that was exchanged between Justice Khampepe and my learned friend, Advocate Semenya SC, and the WhatsApps. And so it's simple. It can be produced now within an hour. So it's not like something that's you have to go and dig into some storeroom or whatever.
But it would seem to me that you are asking for information that you already have in your possession.
Why does it seem like that, Justice?
As I read the papers, is there something I'm missing?
Yes, there is.
Okay.
There's no. That's the accusation false that is made against us. Well, the reality is that if you go to the founding affidavit, Justice, there's nowhere where we say we have the information. This is all we say, all we ever say, and it's common cause. It's not denied. Paragraph 32, sorry, I don't know if the court is there.
What page is that?
001-17, sorry, Justice. And by the way, in terms of Rule 53, even if you're asking for information that you have, that's totally allowed. Because Rule 53, as it was said, Madlanga J said in FUL, is wider than Rule 35. But let's put that aside. Let's assume. But let's come to the real facts. It says, sometime in November 2025, says President Zuma, it was reported to me by a whistleblower that the chairperson had committed actions which amount to bias, gross misconduct, and or corruption, in that she had, inter alia, coached and colluded with one of the parties in the Semenya SC recusal application, namely Semenya SC himself, in that she advised him of weaknesses in his case and even went as far as sharing research in her possession regarding to the disputes and telling him to convey certain tips to Advocate Vas Soni SC, who was representing Advocate Semenya SC. So that's the allegation, not that there's anyone who's got information. It is that a whistleblower informed President Zuma about this. And the response to that is telling, because instead of saying anybody who gets a serious accusation like this would say, look, I don't, as I said in the hearing of the thing, if somebody said to me, Mpofu today on the 16th killed somebody in Durban, I'll have to say no, I was in court and I've got these witnesses and so on and so on. I can't say, well, I don't, how do you know that I was in Durban? And all that. So the point we make is that by the application of the following rules of evidence. One, the fact that when information is peculiarly within the knowledge of one party, that party has an obligation to disclose it. And the other party can use less than the usual levels of evidence to extract that. That is just in a normal case. Forget about Rule 53 for now. It's worse in Rule 53. Remember, one of the things you're not allowed to do in terms of Rule 35, and that's why this rule is wider, is to have what is known as a fishing expedition. Just say, give me this and that and the other. But in my respectful submission, Rule 53 is designed exactly for that, to allow for fishing expeditions. Why? Because of everything that was said in the FUL case by the Constitutional Court. Because let's take a simple example, Justices. In the so-called tender cases, if I say, look, somebody whispered to me that this tender adjudication, there were brown envelopes and what have you, I then do a Rule 53, and I say, I want all the scores, I want all the interviews, I want all this and that and the other. And then you are obliged to give me all that information. Then I supplement. So that's what the rule is designed to do.
I hear you. Can I remind you of time? It's now 11
Yes,
o'clock.
yes. What I will do then, Justice, sorry, I have to deal with the questions, is to refer the court to our heads very quickly. So the heads in the interlocutor application, remember, is 059-1. So the first, I'll just read, I'm not going to read anything, I'm just taking the court so that the court can look at it. From paragraph 1 to 6, we explain why this application is unopposed, for the reasons that I explained earlier. There's just nothing has been done about it. And you'll find that at paragraph 6, we quote those paragraphs when we say, in particular, in the view of the fact that the application to compel is effectively unopposed and not seriously disputed, if it is granted, it is most likely to trigger at least two important consequential processes. One, the exercise by the first applicant of its right to file further supplementary affidavit, which may be waived, and two, the active participation of the NPA in the main application. You'll remember that the NPA has asked specific questions from the chairperson regarding this whole thing about this exchange. And that has been mightily ignored as well. So two things have been ignored: our application to compel and the questions raised by the NPA. And the NPA says, once these questions are answered, we should be answered in this application, then we might even join and get into the fray, and so on, because for obvious reasons, they are interested in this. Then at B, we tell you what the test is. I don't need to tell the court about the test. It's the point I made at paragraph 8. Rule 53 process differs from the normal discovery under Rule 35 of the Uniform Rules of Court. Under 35, documents are discoverable if relevant, and relevance is determined with reference to the pleadings. So under Rule 35 discovery process, asking for information not relevant to the pleaded case would be a fishing expedition. Rule 53 reviews are different, right? The rule envisages the grounds of review changing later. So relevance is assessed as it relates to the decision sought to be reviewed and not the case pleaded in the filing affidavit. I've made that point. Then the test is in Swissboro. Joffy J in this court gave the test of what you have to do. I'll summarize it.
Yes, you deal with that in paragraph 10 of your head.
Yes, it's two things. I just want to highlight what the test is. Two things is existence of the documents and relevance. Relevance is not an issue here, unless my learned friend will tell us differently. And we then go to explain at C the application to compel, as I've already set out, and then we say the relevance of the documents. We've put at C2, that's the most important. The relevant documents exist and are in possession of the first and second, fifth applicant. Then we show why those if the documents are not there, they would simply be denied, not in this cagey fashion or bad denials and that. We would be told exactly that either there's no such documents or here are the emails, but this email you're talking about is not there or whatever. A party is not allowed, in terms of the law, to just play cat and mouse and say and be cagey. It must disclose all. The court knows that the test says you must discover every scrap of paper that is relevant to the matter. And that test was applied by no less than Justice Sisi herself in the case of Public Protector versus South African Reserve Bank, which we refer to. You'll remember in that case, the Public Protector was accused of not having disclosed in the Rule 53 everything. And Justice Khampepe said, you know that in a Rule 53, you must disclose every scrap of piece of paper. It's not for you to say, no, this one is this one is that. Okay.
That is the legal solution, yes?
Yes, and then at C3 we then go to that case, the Helen Suzman case, which says the record contains all information relevant to the impugned decision and so on. And then at the next page we refer the court to the other leading case, which is Democratic Alliance versus Acting National Director of Public Prosecution. You'll remember that's the so-called spy tapes case. And even in that case, it was said that you can't just discover what you want. You must give it all, the good, the bad, and the ugly, and the court will must decide. And here's the important thing. It says it should be made available whether in terms of Rule 53 or by the court exercising their inherent power to regulate their own process. Remember, this is not just for the benefit of the applicant, it's also for the benefit of the court, because the court has to decide the case on the truth, on the real position. Then we referred to you at paragraph 39 to the Mabaso principle. The Mabaso principle is simply the fact that if I accuse you of something, and then you respond by confession and avoidance, then the onus is on you to show the avoidance, so to speak. And that should be, it's a simple mathematical equation. So if you do, you can do a denial, or you do an admission, or you do confession and avoidance. But if you do a confession and avoidance, then you must show the avoidance. If you don't, we're only left with the confession. So it's an admission. Then we deal with the defense of illegally obtained evidence. We show that is just should be thrown into the dustbin. Remember, Justice Sisi and even these applicants say, oh well, these were private communications. Maybe if you intercepted them, you broke the law. But that is telling. It shows that they exist. Because why would you say if we obtain them illegally if they don't exist? You should simply tell us they don't exist. So that's further confirmation that they exist. And in any event, our law says that, and that is the FedEx case at paragraph 45. In criminal proceedings, the accused is under no duty to disclose his defense, nor is he obliged to disclose any documents which might strengthen the state's case. In civil proceedings, the situation is different. In civil proceedings, the position is quite the opposite. A litigant is not only obliged to disclose his case, he is also obliged to discover all documents which may damage his own case, or which may directly or indirectly enable his adversary to advance his case. So that's just in normal civil proceedings, let alone Rule 53. So the law is very clear. And then the issue of the NPA questions, we deal with it at C5, I've already dealt with that. And then in the conclusion, we say that it's clear that this application is not opposed, firstly, except for that one throwaway paragraph. And it should, since it's not opposed, it should therefore be granted. If anything, my learned friend tells you that the application is not before you. I'm inviting him to tell you where is the opposition. And I'm saying that's what is not before you. There's no opposition to this application, none whatsoever. And I would very much like to sit down and listen as to where it has been approved. And yes, and failing that opposition, then the application is to be granted as court pieces.
My Lord, there are 5 reasons why you should strike the application, alternatively dismiss it. The first reason is that it's not set down by the court itself. This is a special motion which was set down by the Lordship. And the special motion is clear that it's the main application that is enrolled for today. There is no set down for the interlocutory application. That should be dispositive of the entire hearing. If they wanted the interlocutory to be set down, the Lordship would have set it down, but that has not happened. The second problem is that it's not set down even by the applicant. So if your leadership and my lords, go to 0052, which is where the application appears, the notice of motion. It says take notice. It's 0053, which is where the actual notice of motion appears. It says take notice that the above mentioned applicant will apply on a date to be allocated by the Honorable Judge President. Now that date has not been applied. And or the registrar. Alternatively, at the hearing. Now that does not, my learned friend then inserts his own words when he says at the hearing of the main application, but that does not appear from the notice of motion. So that is at the hearing of the interlocutory application. But the effect of the matter is that they don't say they will be applying at the hearing of the main application. So even by their own showing, they have not set it down. There is no set down. They issued a set down after your lordship had given the directive, but that set down does not incorporate the interlocutory application. Now that too should be dispositive. So it's not set down by the court, it's not set down by the applicant. Now if you look at the notice of motion of the applicants, although you've heard quite a lot about how the respondents have not filed answering affidavits, there is no requirement there to file an answering affidavit at all. They don't say by this date file an answering affidavit. So you can have a look at that at 0053 and 0054. They don't call the respondent to file an answering affidavit at all. So what that means is that it's also not ripe, quite apart from the fact that it's not set down. It's not ripe for hearing because there's no time allocated for an answering affidavit, and consequently an answering affidavit has not been filed. So it's quite something else for my learned friend to refer to the main application and say there are allegations about disclosure, but it's another to say there is a discrete application which calls upon the respondent to file an answering affidavit, and that has not been complied with. So we can look at 0053 and 0054. There is no requirement to file an answering affidavit at all. So that goes into the third point, that it's also not ripe for hearing. There is a fourth problem, which is that the consequence of what my learned friend is doing is that it actually makes these proceedings unwieldy, the current proceedings.
I missed that. The last one.
It makes it unwieldy, unmanageable. Now, why I say that, if your lordship goes to the supplementary affidavit in support of the notice of motion, you will be struck by two allegations. One is the allegation at paragraph 11 at 005/10, where it says, since the interlocutory application must obviously be decided upfront, I start with the amendments made in support.
Can someone invite me to that relevant page as they were doing?
005/10 at paragraph 11. Thank you. So you will see that paragraph 11 at the bottom of page 3, it says, since the interlocutory application must obviously be decided upfront. So what they want is an upfront decision, not an upfront hearing, it's an upfront decision. Then paragraph 12, the following page, 005/11, needless to say, in the event of the application to compel being successful, I reserve the right consequentially to further supplement and or amend my application. So what we ultimately end up with, we end up with the main review not being ripe as well, because there is this stage that is yet to be completed. The learned friend says he has a right to waive it, but the court cannot work on the hope that maybe it will be waived. It has to work on what it knows. So the consequence is actually enormous for the main application, because you know that under the notice of motion, these documents that are sought have to be produced within 2 days. Now the 2 days, if you issue the order today, will lapse on Wednesday, which will be after this hearing. So the consequences are quite enormous for the main review. It means the main review will simply not be held this week at all, if you entertain this application.
Mr. President, on that issue of 2 days, it it seems applicant has changed or amended that, because he said in his address earlier on it could be produced within the hour.
No, but there is no amendment to the notice of motion, so we have to work on the actual notice that has been given to us, because we also have rights. And you cannot have an applicant that tells you one thing in the notice of motion and then in oral argument they amend, because it means that they are doing it without regard to the rights of the respondent. Quite apart from the fact that the respondent has not been called upon to file an answering affidavit. And in the answering affidavit, it would have explained if the documents exist and the court is minded to order their production, is 2 days enough, is an hour enough, etc. None of those have been canvassed.
Yes, I understand that, but I just asked the question only from a pragmatic point of view. The court would like this matter to proceed to finality as much as possible. And I was asking you, maybe from the respondent's point of view, to whether you could consider that.
No, it's impossible. It's just impossible, because the fact of the matter is that because the respondents have not been called upon to deliver an answering affidavit, they have not even given their version on the very existence of the documents in issue. Let alone if they exist and there is no legal objection to their production, the timing it would take to collate them. So it is impossible to accept a proposition that move from 2 days to an hour. That is why, because of the implications of this application to the main application, you have to strike it.
Mr. Mugaido, allow me to interrupt you at this point. Let's proceed after a 15 minutes again, unless there's something so pressing.
No, nothing like that. I'll continue after.
Thank you. May we take a second?
All right.
No, there used to be a library in this place. I'm sure it's gone now. It's probably gone to somebody's chambers. I asked him to I haven't responded. Just a minute. Please, can somebody rush there?
1977.
Just a minute.
I saw that. I thought you said you wanted. Okay, let's not get to anyone. What is upsetting you?
The thing I asked for more money. Okay, can you say it's 77.4?
97.4.
Please, Councillor.
I'm saying that he asked you for some things that are not here. I don't know. He said this morning he sent a thing on the group.
I'll tell you love it, son. I'm not getting what is it. No, you can arrange.
Hello. Yes, where's the document? Yes, and where is it? The opposed one? Where is it in the case line?
What knows what I say? Is it the one you said us there? 00725. 00725. Okay, hold on.
No, it's nothing like that.
What is this document? What is this document?
Opposition to the application to compare. It's in the. You must read the my WhatsApp.
Yeah. It's, no, not 25. Opposition to the application to compare. That is what the notice of.
No, telling the other side.
Okay.
But this one should come with this week.
Do I get it now? Sorry? I do not know what you mean. I'm asking you.
Yeah.
Sorry? Yeah, who's that?
This many years ago. And I know, it was during the days of checks were gone. And I know I get money from that. But you don't know. Yeah, we live. It's still net bank. Those are good days.
What knows?
No.
Are you there?
No.
What is it? Hold on.
People say way less than yeah.
Now we're 11.
relevant paragraph is paragraph 200. So I will have to see how I get there quickly. So 200, I think my so I think and I think I've got a wrong reference because I've got the reference from the report that I had a look at, trying to see where exactly the paragraph is. I'm trying to get the right paragraph. Of the majority judgment. 210. It could be that you saved my bacon, Justice Mbeki. I'll have to share my fee with you today. No, that's Justice Froneman's judgment. I'm looking for the judgment. The passage is in the judgment of Jaffa J and Khampepe J.
That's
oh yes. It's 201. I'm thankful to the junior that spoke from the back. It's 201 at 055B197. Now, if you look at that's the majority judgment. It says, as mentioned, we agree with the first judgment that the appeal should succeed. Where the jurisdiction of the court before which a review application is brought is contested, a ruling on this issue must precede all other orders. This is because a court must be competent to make whatever orders it issues. If it lacks authority to make an order it grants, that order constitutes a nullity. Scarce judicial resources should not be wasted by engaging in fruitless exercises like making orders which cannot be enforced. So if you look then at the combination of paragraph 118 and 201, what are the implications for this case? The implications with respect are actually quite simple. The validity of these proceedings is challenged. This court is being asked to rule that it has no competence to entertain these proceedings because they are invalid ab initio. But at the same time...
That also goes to the merits. That also goes to the merits, am I right?
Yes. But at the same time, it is being asked to issue interlocutory orders. But it has not yet ruled on whether or not these proceedings are validly instituted. Now, the Constitutional Court's guidance on that is that you cannot make further rulings until you've decided the question of your own competency. So the question of the validity of the proceedings, according to the language of the Constitution, must precede all other orders. Because if you issued an order now compelling the Commission to produce documents, and then in the next 3 months when you write your judgment, you uphold the Section 47 point, that order would become a nullity and it would not be enforceable. And that's why we submit that for various reasons, this application to compare is either premature, it's not right, it's not set down. In any event, it's brought out of sequence. The correct time to decide it is after you've decided whether or not the proceedings are validly instituted. Thank you.
Mr. Mbeki, this court is also bound by the rule against piecemeal litigation. I'd rather raise this issue with you when the discussion changes.
Yes.
So how do you rank that rule?
But that doesn't.
You just say?
Yes. No, that doesn't apply to. That rule doesn't apply where the very validity of the proceedings is disputed. So we've taken a number of in limine points. So one of the in limine points we've taken is the fact that the applicants cannot show exceptional circumstances to depart from the usual rule that you must first wait for the proceedings to be completed. We accept that that issue must be decided together with the merits. It's bound up with the merits. But the question of the validity of the proceedings is a separate and separable issue that goes to the question of your own competence. Because if you have proceedings that are void ab initio, that question precedes everything. Your learned colleague, Justice Judge who wrote the judgment in the Mantashe case, Justice Deepener, has made this point very clear that the non-compliance with Section 47 is not mere non-compliance with legislation, as you would do with Rule 612, but it goes to the heart of the validity of the proceedings. So if there are no proceedings before you, you cannot issue other orders. You have to uphold or dismiss the contention whether there are valid proceedings before you deal with any other matter. And the logic for it is very clear. It's set out in the judgment of the Constitutional Court that the consequence of doing it the other way is that you give yourselves powers that you don't have, because you then entertain invalid proceedings and issue orders that are hollow because they have no legal basis. So we would accept that where an issue is bound up with the merits, it would be wrong for us to try and separate it. But the Section 47 point is common cause. It's common cause there was no request. It's common cause that there was no permission. The only issue that is contested by the parties is what are the consequences of the non-compliance. Does it result in invalidity or does it not? You've heard the submissions by Mr. Maineche on the point, but the fact of the matter is that he's bound by the judgment of Deepener J, unless he can persuade you that the judgment is clearly wrong and should not be followed.
We are yet to hear him. I'm sure you are referring to his heads.
Now the problem, my lord, that's why I was saying to the court that we had no issue with any of this. The problem is that if you are asked to make an order now, that issue then becomes pertinent. Otherwise, it would have been fine for us to wait until they argue. and then to raise that issue at that point. But because you are being compelled to issue an order to disclose documents, the question of the authority of the court is then a main issue that must first be crossed.
So you mean you are being asked to issue a compelling order?
The court is being asked to issue a compelling order, yes. So I'm saying then, thereafter, at that point, then there is a clash, because then you must decide your authority. Ordinarily, we would have waited our turn in the queue and not raised this point, but the problem is that it's raised sharply now, because we have an order that is going to be granted, an order that we say would be incompetent because of the non-compliance with Section 47.
Anything else?
Thank you, ma'am.
Mindful of time?
No, I'm finished. Thank you.
Ms. Khampepe, it's your turn.
Thank you, my lord. Well, my lord, I'm tempted firstly to deal with this last point, even though it is said as number 5. It's obvious that it's not true that the Section 47 issue is common cause. And it's the first time that I hear that a full court is bound by a judgment of one judge. It is not. We all know that. But we'll come back to that. The situation is this, my lord. Whether this court is going to allow this party to make a mockery of Rule 53 or not. Rule 53 does not allow for this kind of ducking and diving. It says you must be candid, you must disclose, you must place the court in a position to decide the matter. That's what the rule is designed for. That's why it's different from Rule 6. And that's why Rule 53(1)(b) is different from Rule 35. So a party is not allowed to do this. And I don't want to be repeating myself, but a party that says, if somebody says, in my house there's cocaine or whatever, I will say, here's the key, because there's no cocaine. I can't say, how did you get in? You broke through the window, you jumped through. No. You are, once the information is peculiarly within my knowledge, then you have to disclose it. Now, Mr. Ngokatobi, let's go now one by one. He says, startlingly, that the main reason why they have ignored the application is because in the notice of motion, there's no set times. Where has that ever come? Rule 611 is very clear, my lord, that in the case of interlocutory applications, you use the short form, not the long form. He's talking about the long form. Long form is the one that says you must file by such and such a date, and so on. And the authority for that proposition, you'll find it's in many cases, but there's a specific case which we've just printed. We will upload it if it's not already there. It's a case of Gisman, H-G-I-S-M-A-N. But it's quoted in Erasmus at D1 Rule 6-50. And it says, the provisions of the rules relating to the time for filing answering affidavits and replying affidavits do not apply to interlocutory applications. It's very simple. So what happens is, so Mr. Ngokatobi's complaint is completely invalid. The short form, by definition, says that you must file within a reasonable time. So what's a reasonable time in the context of these proceedings, which have already been set down on an expedited and urgent basis? Surely that time cannot be after today, when the matter is heard. So we still don't have the answering affidavit. So it is impossible that there'll be compliance with Rule 611. Okay? So that rule, that goes for number 1 and number 2 of his But here's the, you know, it's very rare that you get the smoking gun in a case. Here's the smoking gun. Go to 007-27. Mr. Ngokatobi's attorneys filed a notice of intention to oppose the application, this application. And now it tells you they didn't know what to do. They knew exactly what to do and they did it. Here, it says, their notice says, kindly take notice that the first to fifth respondents, that's Mr. Ngokatobi's clients, hereby give notice of their intention to oppose the applicant's application to compel compliance with Rule 53(1)B of the Uniform Rules of Court and appoint the address of the attorneys and so on. All documents and notices is this matter. And they consent to documents served by email. Boom. So there goes the contrived reliance on the fact that the notice does not set out times. That notice did not say that they must file a notice of intention to oppose by 23rd February, but they did, because they knew that they have an obligation to do so in terms of Rule 611. What they have failed to do, having put the notice to oppose, is then to follow it up with an answering affidavit. That cannot be a fault, that's their fault. It's an election they made, they must live and die by it. So once they make that application, having said they're going to oppose the application, what are we supposed to do, honestly, except to wait for an answering affidavit, which has not come until today? So the application is unopposed, it must be granted by default. You remember, well, in normal default judgments, there are two types of defaults. One, if you fail to put a notice to oppose, they don't fall under that because they've put a notice to oppose. The second one is if you fail to put a plea or an answering affidavit, they fall into that one. So that's it, really. I don't understand why we're having this debate. Secondly, Mr. Ngokatobi, so that's ground 1 and 2 flies away because of the notice of intention to oppose, which they've never done anything about. So which court is going to say, oh, well, you were not told to do an answering affidavit, but you were not told to do a notice of intention to oppose, and you put it, but you were not told to do an answering, but you didn't put it. I mean, that's just plain gymnastics. Then, so the interlocutory application, that case which I wanted to refer to is Gisman Mining and Engineering versus LTA Earthworks, 1977-4.
Is it in the bundle?
It's, is it? Yes, it is now, yes. It's 1977-4 SA 25W reference? 055-207. And it's referred to, anyway, the better discussion is the one in Erasmus. Then, so number 3, he says that he then gives, I'm sorry.
Can you assist us with a reference
For the case.
for the part of the case that you rely on?
Oh.
Paragraph.
Yes. It is just before paragraphs were invented in judgment. So it's at page 27 of the judgment, Malay. Yes. It's judgment of Makiwan-J.
In Erasmus, what footnote is that?
Yes, I said it's a D1
Yes.
Rule 6-50. I hope mine is updated, but I think it is, yes. But it's in the commentary on Rule 611. Then, number 3 says that, then Mr. Ngokatobi, I don't have to respond to anything that he said. All the nice legal points that he's raising should have been raised in the answering affidavit. You can't raise them in court now for the first time. So assume everything he's saying is true. All that is supposed to be put in an answering affidavit. If you wanted to rely only on legal points, there's a rule 65D Roman 3, which is catered for that. So you might say, I think it's not worth responding to all these accusations about the email and what. I'm just going to take the legal points, like the one he's just taken now, about section 47 and what have you. That's what an answering affidavit is for. It's not for the court to fathom now, to be told now about all these interesting esoteric legal points. Because why? Audi alteram partem. We would have known about this and we would have responded to it. All this, the points, by the way, are totally invalid, but that's not even the point I'm making. I'm saying assume that they are valid. But they should have been put in an answering affidavit. Number 4, he says it's impossible to do this because the respondents have not been given time to do an answering affidavit. That falls with number 1 and number 2, and so number 4 is totally invalid. Then he says, well, it's so difficult for you, court, because if you grant this, then we may exercise our right to supplement, even if, as Justice Parker put it, even if you do it within an hour, there's no guarantee that we may not exercise our right to supplement. Despite, and I'm not in a position to make undertakings that we want. I simply said that we have a right, we could waive that. But nobody can force us to waive our rights. So if the outcome of receiving those emails is that we want to supplement, so be it. That's what the law entitles us to do, and that is what we may or may not do. So there's no way that we're going to say we want, because, by the way, if those documents are discovered, that might be the end of this case. So all these things about the fears about whether the merits and this might never materialize, because we will now have the email that is alleged to be in breach of the JSC code and Section 8 of PRECA in this country. The last one is, quite frankly, laughable, because Mr. Ngogaitobi knows he was in that case of Competition Commission. And that's why we put it here. We knew that they were going to try and invoke this case. Well, firstly, that case does not assist them at all. Actually, if anything, it sinks their case. Firstly, it is true that at 118 of the minority judgment, mind you, so it's a minority judgment, and at least Mr. Ngogaitobi admitted that much. And you'll find that at 055B-168, that it was said that if there's a jurisdiction issue, then the jurisdiction issue should be decided up front. That makes sense, makes perfect sense. Except that in this case, there's no jurisdiction issue. The only issue that is raised by them is this issue of Section 47. That's not a jurisdiction issue. It's something that says you did not get consent. The courts have been at pains to point out, because we normally say Section 47 breaches Section 34 of the Constitution. And the courts have been saying, no, it doesn't breach Section 34 of the Constitution, because it's not a bar to your claim. It simply says you must go and ask for permission from the JP and so on. So it's not a jurisdiction issue, number one. Number two, even if it was, the Rule 53 is a sui generis type of rule. And the answer to this is found at paragraph 120, the one that Mr. Ngogaitobi did not read. And it says this, my lords and my lady, that the obligation to produce a record arises from the institution of the Rule 53. Let me repeat that. The obligation to produce a record arises merely from the institution of the proceedings. In other words, once I put my founding affidavit, the first one, not the supplementary one, then the obligation to file a record arises. And this is what it says at 120. This finding is entirely consistent with what the SCA, I'm reading from 055B-169. What the SCA have said about the importance of Rule 53 record and its availability to litigants. This is because a distinction must be made between the jurisdiction of the forum to hear the review application and the merits of the review application. Let me pause there. Also, oh no, let me not pause, because that poses other problems that were raised by Justice, I think Justice Bakwa, no, it's Justice Mudiba, about the, remember the parties here have already agreed, and you've been told, that the merits and the Section 47 are going to be heard all together. So that postulation that Mr. Nkaitobi makes will never happen, where the Section 47 is just heard up front. Because here we all agreed as parties that all those nice points in limine are going to be debated with the merits. So we might as well call them the merits. So what he's really saying is that you must decide the merits before the discovery is done. But here's the real punch. Sorry, I was just pausing. Would you mind if I...
So can I just interrupt you?
Yes,
recall
of course.
When you were addressing us on the times, there's an issue I raised regarding the discussion we had in chambers.
Yes.
What ought to have been argued is whether this application is before us or not. We did not agree as a bench. We didn't agree that this application should be separated out. We didn't agree to any issue being separated out.
Yes.
And you started by showing us the point Mr. Nkaitobi would have taken is that the application is not before us and it's going to be stopped. And your issue was that the application is before us. That should have been the end of the matter.
No, Justice Mutiba. I accept that that might have been, but the bench also said to the parties, in full view of everyone else, parties go and agree how the matter is going to be conducted. We presented that agreement to you. Nobody said this agreement is not what, because the parties what? Agreed.
You are referring to the time allocation, are you not?
Pardon? Yeah. Yes, about the whole thing. And that's why I said, I had said in chambers it will even take less than 5 minutes, and someone said 10 minutes. Why? Because that is exactly the proposal that was agreed now is the one that we had proposed. But that's besides the point. The point I'm making, Justice Mudiba, is that once the parties have agreed, so let's say, for example, we had agreed that we'll start with the condemnation applications. And then we come together and we find that, no, we're no longer opposing the condemnation applications. The court can say, no, but we agreed we're going to start with the condemnation applications. Because the parties have agreed, they've now agreed that this is how we're going to proceed. Let me come back to the real issues. If it says, and I'll address the procedural point, Justice Mudiba, I'm not running away from it. I'm simply saying that I just want to, that might not be relevant depending on what I'm going to read. It says, if a review application, remember, maybe let me just address this quick. Justice Mudiba, maybe the straight answer to your question is the following. The parties have now agreed that we will, instead of wasting the time of the court, address that primary question together with the application itself. That does not stop the court from saying, well, we've decided that it's not before us. We can't impose that on the bench. But what we can at least agree is to try and save the time of the bench.
And there lies in my concern.
Yes.
Something that has been agreed upon that it will take about 15 minutes or so. We are now about 2 hours down the line.
No, that's firstly that
1 hour, it is more than an hour.
Timber. No, that's not. Maybe I don't know if the thing has reached. According to that document that was sent to you, this application was going to finish at 12, and I think we're only 10 minutes up. So I don't know the 2 hours.
What I hear you saying is that you may have agreed to deal with both the procedural issues regarding the interlocutor application and its merits in this time allocation.
Yes,
right?
we did.
But as to how this court rules on how it should be done, that is...
It's out of our hands.
It's out of
That's absolutely nothing to do with us. It's that side of the bench. Okay. So, if I can just finish this here. It says, if a review application, I read this slowly, is launched in a forum that enjoys jurisdiction, and let me pause there. This forum enjoys the jurisdiction to deal with the Rule 53 application, both in terms of Rule 53 itself, but also in terms of PAJA. PAJA, there's an exception in PAJA, or rather none of those exceptions apply, but we'll deal with that when we deal with the points in limine, because that's one of Mr. Nkatobi's points in limine. It says, then a party is entitled to the record even if their grounds of review are meritless. That's what it says here. This is a constitutional court that he was quoting. It says, as the Supreme Court of Appeal put it, quote, the obligation, and this is my real point, to produce the record automatically follows upon the launch of the application. However ill-founded that application may later turn out to be. Right? That is from the CompuTicket case, which I will give you the reference now, Justices. It's Competition Commission versus CompuTicket Pty Ltd. And it's big bracket 2014 Zaska 185. And that's an SCA decision. And the Constitutional Court was therefore endorsing the obligation to automatically upon the launch, however ill-founded. This is because, as recognized by the majority decision in Helen Suzman, another Constitutional Court decision, Rule 53 envisages the grounds of review changing after the record has been furnished. That's the point I made earlier this morning, that it's a legalized fishing expedition. The record is essential to a party's ability to make out a case for review. It is for that reason that a prima facie case on the merits need not be made out prior to the filing of the record. So that's paragraph 120 of the judgment that Mr. Nkatobi seeks to rely on. It's wrong that he thinks that the obligation comes before. But here's the showstopper. Let's assume Mr. Nkatobi believed what he's saying here. Then the rhetorical question is, well, if that is so, why did they file the record? Why? Because here we're not dealing with a situation where they say the obligation to file the record arises after the Section 47 has been done. Before the Section 47 question was resolved, they filed the record. This case, this application to compel, is not about the obligation to file the record. It's about the fact that having filed the record, we are saying we want better and further discovery. That's a different kettle of fish. So it's not a Rule 35.1, if you want to use that analogy, where you're saying, please discover now. No, it's a Rule 35.3 or Rule 35.7, where you're saying, having discovered, I'm not satisfied with your discovery, discover better. So that defense, based on the Constitutional Court case, falls flat. because they themselves have waived their right to refuse to give the record on the basis that they are waiting for some Section 47 determination. So much for all those 5 points. The point is this, Justices, and I invite your Justices to read the Helen Suzman case.
Well, before you
Sorry.
do that,
Yes,
just on the submission you made, just
the last one. Yes.
that they waived their right. Are you suggesting that their rights in terms of Section 47 was waived?
No. Thank you, Justice Bako. No. Let me explain what I'm saying. I'm saying if you say there are two different things. Scenario A is the party against whom discovery is sought can say, but what are you talking about? Let's say it's a normal trial, forget about Rule 53 for now. What are you talking about? Because you know that the trigger for discovery is the close of pleadings, litis contestatio, right? That's scenario 1. But scenario 2, which is where we are, is totally different. Whether all the parties now agree that we've reached that stage, the party has even discovered, but all you are saying is that, no, you have not discovered enough. We have to conceptually be able to distinguish between those two scenarios. We are in scenario B here, because they have actually produced the record. In other words, they've complied with their obligations under Rule 53 and what the Constitutional Court said here, that the obligation comes as soon as it's launched, the obligation to produce a record arises. They've complied with that. They can't now turn around today and say, no, the obligation to file a record has not arisen. They can't do that. It's not done. And no court can entertain from the bar such a proposition, which is not even put in any answering affidavit or a Rule 65D3 notice, to say the least. So that's the submission. It's a very important submission. You know, it's like saying, I do a plea, and then I come to court and I say, no, but I was not even, the other side says, no, but you did not plead to this paragraph and that paragraph. Then I turn around and say, well, I didn't even have to send you a plea. It's too late. So all in all, Justices, the situation is that Mr. Ngubatobi has confessed before this court that they did not oppose the application. And he says they did not oppose it because we did not give them time to do answering affidavit. That reason is invalid in law. So, yeah, so that reason, because there's no such obligation, in terms of Rule 6 law.
Fair enough. I'll give you about 2 minutes to wrap up.
Yes, thank you, ADJP. You're very generous. Again, I'll refrain from going to the heads. Let me just say this about why you can't litigate like this. You can't just close your eyes and hope that somebody is going to rescue you. We give a notice, and it's not answered to. The NPA puts questions in an explanatory affidavit, which means it's for the benefit of all of us. And the NPA says, we are worried about this allegation. The chairperson must answer these questions. Sorry, sir. You'll find that at 006-1 onwards. It's the affidavit of Mthunzi Columbus Maga. They put questions. They say, in the light of the seriousness of the allegations, I'm reading from paragraph 17, we respectfully submit that the court would benefit from a clear and candid answers from the chairperson on the following issues. 1, whether the chairperson at any time communicated directly with Advocate Sminya SC outside the formal processes of the commission. 2, whether on or about 5 November the chairperson sent communication to Advocate Sminya from her private email address and the content of that communication, whether the chairperson at any stage suggested or provided legal authorities, research material, or lines of argument to Advocate Siminya, whether the chairperson communicated with Advocate Siminya via WhatsApp or any other messaging platform concerning the recusal application, whether the chairperson advised, guided, or alerted Advocate Siminya SC aspects of the NPA's recusal applications, and so on and so on. So for time, I won't read all of them. Those are questions that are put here by an organ of state, which is not taking sides. It's simply saying those questions coincide directly with what we're asking in the application to compare. And the NPA goes to say, if these are answered, we might change our stance somewhere in the conclusion and participate, because now, so these so-called merits we're talking about are dependent on this. Last point, please, Justice. The Section 47 excuse does not wash, because assume for a minute that you hear the merits together with the Sections 47 point, and you uphold Mr. Mokatobi's Section 47 point. That still, on the proper reading of the Constitutional Court, that still does not alleviate their obligation, because it arose the minute they received our 53 application, and they knew that. If they didn't know that, they would never have produced the record. So all in all, there's an application before you. It's unopposed by the say-so of my learned friend, for a reason that is invalid, that is just a misreading of the law of Rule 611, because Rule 611 is different from Rule 65. And 3, the authorities relied on do not support that proposition. And 4, since the application is by default, and it's important to the determination of the merits, the court has no choice but to grant the order. And as Justice Pakwa indicated, if the court says it must be done within a shorter period to assist the court, well, so be it. But what this court cannot do in South Africa is to allow a party to play cat and mouse and not discover and put the court at ease and the parties to determine the Rule 53 application. If that happens, then God save us all. As a court. I appreciate it. Thank you.
We are going to take a very brief adjournment to consider our position in this regard, and it should just take a few minutes.
Thank you.
Unless you want to note the judgment from the front. But one thing I know, if you go the whole back
I had that one before.
It's going to be a
I don't know how we're going to make Are you one of them? Yeah, you look like you look further. You look.
But I thought that I didn't enjoy it. I joined
Well, I'm going to tell them.
So do we go to
It's up to them because I'll place it on I can't believe that.
no snacks, nothing. I got you water. Oh, now we are late on the snacks. Do you not have an iPhone charger?
What's your ticket? These ones are going to dismiss it. Initially.
But now,
So you mean I've been for the past 2 months? So,
You may not like our family.
clients doing such and such case, they don't consult every 5 minutes. Now, should I stand up? Should I sit down? No. Wait, just wait.
Kaitobi assist.
Yeah, that is always a problem.
Yeah, that is always because when it doesn't matter who delivers the message is valid, it has to be done.
Yeah. I'm saying that's what take it, my stuff.
Everyone thinks that they
You were really
it's a famous of the road. That's why no, they should never
Does that mean we...
That's it.
Down until tomorrow, until 2 o'clock.
Yeah.
I mean, it's just evening. I'm not saying my time will go. Columbus.
Was there something else or something?
No. I'm sorry. I was just ready for the next.
Oh, ready for the next?
Yes.
We have had argument on the interlocutory application to compare the filing of the better report in terms of Rule 3.1b. Our rulings as follows. We will hear arguments on the remaining issues. We reserve that one.
As the court pleases. So, Justices, I must just please. This is now when we go to the next level. Yes,
Let's go
but
on with the merits.
to the next level. Yes, the merits. Yeah. But I have to say this because one day it might be important. That for the record, our proceeding to the merits, we reserve all our rights to raise this issue at any other stage, because particularly the issue of how it is that we can get into the merits without the record. But that will be dealt with, I suppose, in other proceedings. In fact, yes, let me not go further and postulate things that have not happened. But if it had been found that there was no such obligation, then I would have informed you that our instructions would have been to note an appeal on that point and then leave it in the hands of the court. But the court has taken the view that it has taken. And as counsel, we have no choice but to comply. Yes.
We are court of law.
Yes. Comply and complain later, they say. Yeah.
Let's proceed.
Yes, thank you. Right. Now, even proceeding in the dark, as it were, without the full record, in our respectful submission, the application should be granted, and that now takes us, my lords and my lady, to the main heads, which you will find at 055-9. Now, my lord, you'll see that, I'll follow the scheme of the heads just so that we work together with the court. But obviously, I'm not going to just read them out. Now and again, I will pause and raise the points. And the first point we raise, by the way, we were assuming by now we'll have the record. But we make the point in the preamble, which is very important. It's relevant both for this and the previous section. We're in a CJ as long ago as 1913. I don't even know how many years ago that was. In the case of Union Government versus Sykes. Oh, I'm sorry. The NPA wanted to say something. Thank you.
My lords, my lady, just for the National Prosecuting Authority, we have filed in this particular matter and it cuts across both for the interlocutory and the main matter, an explanatory affidavit that actually does go into that issue of the record. And my instructions are to put our reservations, because whether or not we become a co-applicant or respondent in this matter, that record becomes very pertinent, because the allegations made by former President Zuma go directly to our application, where a recusal application was brought in the commission. And that's the reservation that we have been asked to put on record.
I'm sure the report will speak for itself.
Correct. Thank you. I'll say nothing about that. So, Ines CJ said, the important point is that less evidence will suffice to establish a prima facie case where the matter is peculiarly within the knowledge of the opposite party than would under other circumstances be required. Now, what that simply means is that in this situation where we are litigating in the dark, the court is entitled, and we will argue strongly that it has an obligation to look at the pleadings as they stand and make the determination that we make. I'll start with the determination before I even justify it. Our bold submission is that to the extent that the existence and content of the emails and WhatsApps has not been denied properly so, in line with Plascon Evans, Whitman, and all those cases. The court, I don't have to bore the court with all those cases. The court knows that it is said that if a respondent gives just a bold denial and does not give the meat, then it might as well not as much as it has not said anything. Now we say, given those circumstances and given this principle of Ines CJ, then the court has to work on the basis that there has been no serious and true denial of the existence of those documents. There's another rule called the rule in Gallant versus Dixon, Galante versus Dixon. We have put it in the heads, and that rule simply says it was in a motor accident situation. If I say there was a motor accident and there was negligence, and the driver just says nothing or dilly-dallies around it, then the court must choose the inference that favors the plaintiff. In other words, that favors us, the applicant, which is that the document is there. So I'll put that aside because I don't want to belabor that point. So we are totally handicapped, but we will hop along with the case as it is. So let me start then, Justices, with the preliminary points. Remember, there are two sets of preliminary points. They are raised in section E of our heads. So E1 to E3, you will find at paragraphs from page 14, typed page 14, paragraph 47. And I want the court to be pleased with me on this. So we have, under that section, we have 8 points, right? The first three, E1 to E3, are our points that we're raising up front. Then we deal with the other 4 or 5 that are raised by the other side in one go. Yeah, all right. Now, the ones that we raise are as follows. We say, and again, we don't want to prolong this unnecessarily. Let me explain what we say in E1. We say, remember these are, I don't know, people keep on, oh, this is from the journalist. Because I thought someone's going to say it's my phone that's ringing.
They want to hear.
Yes, they do.
And to quote you accurately.
Yes, thank you, Justice Madam. Now, we say, you know, a court case can be all this complex with all these luminaries over here. But if you look at the pleadings, you can find that there are 4 or 5 discrete cases. In other words, if I have a claim against you in delict and another one in contract and another one based on the Companies Act and so on, it is my obligation to put all of those in one document. It's called the once and for all rule. So I can't say, no, today I'm here for the declaratory order. I'll bring another application for the review. Then I'll bring another application. But that should never make us think that those cases are not separable. Why am I saying this? There is a separable case that has been made against the President of South Africa in the supplementary affidavit. It is made both by the Mbeki applicant and the Zuma applicant. And that case, quite frankly, has got nothing to do with the other respondents. It could have been brought separately as Zuma and Mbeki versus, and I mean no disrespect, as I've said in the head, when we use without the titles. It could have been by President Zuma, President Mbeki versus President Ramaphosa. And that case must be understood on its own 4 legs. That case is very simple. It says, President, you are asked to remove and terminate the the appointment. I'm paraphrasing. Yes, thank you so much, Justice Sisi. Now, that case, to the extent that it exists, the President has responded and says, I'm not opposing, in so many words. It's not some roundabout thing where we need to interpret. So, as far as that case is concerned, the court should give the order right now, because that application, to the extent that it's an application in its own right, is not only unopposed by President Ramaphosa, he actually goes to support it. So there is no reason, there's nothing that anybody sitting here can ever say that will, except for the President, unless if the President says, I've changed my mind. Of course, he can say it. But other than that, there is nobody in this earth who can say that application is now being opposed. So we make that point at E1. And then we say, if the court boldly agrees with that assertion, which is unassailable in my respectful submission, then that should be the end. We should all go home. Because there is no other reason. Our objective is the removal or termination of the appointment of the chairperson for the reasons, particularly the actual bias, alternatively the reasonably apprehended bias. Now, admittedly, and for good reason, the President says, I'm not getting into this thing about the actual bias, because he says, I don't know the facts. Fair enough. But he says, as far as the reasonable apprehension of bias is concerned, I am saying that there is a case to answer, and for that reason, I'm not opposing, and for that reason, the court is at large in our respectful submission to grant that. That would be the end, and that's why we're raising this up front, because if the court were to do that, we all pack our bags and go home. But it's unlikely that the court will do that. So, that point remains. The second point we raise under E2, my lord, is that, sorry.
I wanted to say...
On the first one?
Yes.
Yeah.
That one. The photos of Vicky in terms of section 84. You can't say anything more now.
Yes.
He's expressing his views, which is entitled to. He's an opponent, but so.
No, he's not. But in any event, let's assume for a minute he is. The point of the matter, the point I'm making, is not whether there's a good defense or a bad defense by the president. The point of the matter is that the relief sought against him is unopposed by him, and it ought to be granted. Now, of course, Justice Barker, you and I know that does not mean the court, even in unopposed motion court, the court is not mummified from saying, well, but Mr. Mbofu, paragraph 3 of your notice of motion and so on. And that's not what I'm arguing. I'm making the point that, in fact, let's come to the functus officio thing. No, he's not functus officio. Because, firstly, the functus officio rule, it's not clear, I think one of the parties at least acknowledges it, that it applies to executive decisions, firstly. Secondly, if you go to 009-263, remember the Masatla rule, he who appoints has a right to dismiss. So the president could very well, as much as he appointed the chairperson, revoke that appointment. Nobody would say he's functus officio.
You would have saved you a lot of pain and time.
A lot. Oh, and more sleep. Thank you, Justice Muda. And if you go to 009-263, that is confirmed by the terms of reference. The terms of reference for the appointment of this commission say at paragraph 3 thereof, these terms of reference may be added to, varied, or amended by proclamation from time to time. In other words, the president could vary. Remember, one of the terms of reference is that in terms of 82-4F, I hereby appoint Justice Khampepe, Honorable Justice Homo, and Gabriel S.C. on the other page, and so on. So he could invoke paragraph 3 of the terms of reference and vary that appointment and say, I'm now appointing Judge X or Y, or Mr. X, or Reverend X or Y, whatever. Or I'm not appointing anybody. I want the commissioners that are there to continue. So that there's no functus officio. He's actually empowered by the. But anyway, let's put that aside. At E2, we talk about the status of the answering affidavits. I'll be short on this. There, the point has been made. We say that the answering affidavit of Advocate Semenya SC, even in this matter, has not been properly authorized. And I don't think anybody can doubt that. We all know from grade 1 that if there's an affidavit and I'm representing Mr. Manager or his company, I must either have his confirmatory affidavit or resolution. No such thing here. We're just told that the chief evidence leader represents the commission and represents all the other, just like that. Nobody says they met and then they agreed that they authorized me. Why? Because it is known that there's no such authorization. There's nothing in law, at least that I know of, maybe Mr. Nkhaitebo can enlighten us, that entitles an evidence leader, qua evidence leader, to do an affidavit. If it was a secretary of the commission, that's a different matter, because that person represents the commission. But an evidence leader is not for here. He's for there, where they are doing leading witnesses and cross-examination and so on. So there's nothing that entitles him per se to file that answering affidavit. And we make that point that it therefore means that there's no answering affidavit before you, at least in respect of those respondents that he purports to represent. And to that extent, his affidavit must be read as pro non scripto. Again, if the court agrees with that, we go home. Because it means there's no answering affidavit, just like Mr. Nkhaitobi's case. There's no, and if it's not there, it's not there. So we make that point. The last point, which will make an E3. And I'm the first one to admit that this point straddles between being this preliminary point and also touching on the merits. But it is this, and I'm just explaining why we put it up front. We say, Justices, it is now common cause that the ruling which brings us all here was only signed by the chairperson and was only produced by her and not by the commission. That much is admitted. Now, we say that raises two different problems which could give us an early shower to go home very quickly. Again, I keep on dangling that possibility. Why do I say that to this bench? It is because, remember, if we are here and it is found that, or at least it's common cause, that the decision was given by a body that was not properly constituted, then that should be the end of it. Why am I saying that? Just as this panel is sitting here, if tomorrow a judgment comes that says only Justice Pakwa is giving this, and we don't know what the other two judges had to say, that by definition cannot be called the decision of the court. It will be a decision of Justice Pakwa. Yes, please.
Does anything tell on this? Is it not so that the application for recusal was addressed to the chairperson?
Yes.
She's the one who's being asked to recuse. She gives you a reason why she does not agree that she must step down.
Yes.
Does anything tell on this?
A lot. The first one is that is not the law. The law, if you go to paragraph 17 of our paragraph 59, sorry, Judge. It says, and we all know this, a judge who sits in a case in which she or she is disqualified from sitting because seen objectively there exists a reasonable apprehension that such judge might be biased, acts in a manner that is inconsistent with Section 34 and in breach of requirements of Section 165. And then, if you go further down, we have no doubt, therefore, that the application for refusal raised a constitutional matter within 167, and that, here's the important part, it was the duty of this court, not the judge, to give collective consideration to the question whether the judges concerned should recuse themselves. In other words, simply put, it is the collective decision. If I say Justice Pakwa, I'm sorry to make this example, Justice Pakwa, is something disqualifies him. It can be his decision. Of course, he'll bring the facts and so on, but the decision is a collective decision of this bench, and that's what was found in Sarfu. Right. Number two.
Mr. Mbeki,
Sorry.
can I ask you a question?
Yes, please.
Before you move on the point you've just dealt with.
Of course.
Because I've looked at this section of the Sarfu judgment
Yeah.
very carefully, because
Yes.
the issue you raise is of great concern.
Absolutely. Thank you.
And I want to ask you whether the facts in Sarfu are not distinguishable from the facts in the current matter.
Yeah.
Because you will recall there that the recusal was sought against 5 of the
10 or 11,
judges
yes.
on the bench. However, there was also a complaint, I guess, against the members of the bench in respect of whom recusal was not sought. There was a complaint. And
One of the members, correct.
Mr. Bate had said, he said he leaves it to their conscience to decide whether they will sit or
Yes.
recuse themselves.
Yes. Fair enough.
So in this case, there was only one recusal application against Justice Khampepe, no complaint against the other two commissioners.
Yes, but Justice Mudziba, surely, if that was the case, then what were the other two commissioners doing at the hearing? Because if that is the case in my example, you would then just leave and go and do your other work and leave Justice Pakwa here to deal with the recusal application. It doesn't work like that. It has never worked like that anywhere. Once the panel sits as a panel, then the decision must be a decision of the panel. It's really.
Let me take you to the second question I wanted to
Yes.
ask you. I note that in your heads of argument, where you quote paragraph 31
Of SAFU, yes.
you only quote the last sentence.
No. Okay, well, let's get the full thing. Yeah, well, that's because heads are not.
Whoever prepared the heads.
Yes.
quoted-
No, they were prepared by me.
Yeah, the
You
last
can say me.
sentence, without
Yes.
indicating that paragraph actually has preceding sentences.
Okay.
So I want to just draw your attention to the first sentence of that paragraph,
Yes.
where the court, it's a judgment of the court says,
Correct.
judges have jurisdiction to determine applications for their own.
Yes, but that's a different point, Justice Mudiba. Of course, that addresses the following point. In the normal course of events, if I was saying, I'm not happy with you, Justice Mudiba, then ordinarily I should be saying, you can't even be listening to me now, right? I want another judge to determine whether you are conflicted or not. That would be the normal logical thing. But judges, because of their status, are allowed to hear their own recusal application. That has nothing to do with this question about whether it's a collective decision or an individual decision. It's true, that sentence that says judges are a special breed, so to speak, who are allowed. It's just like it's the most peculiar problems for us, at least as lawyers, is this and the application for leave to appeal. Because the same thing, same application for leave to appeal, you have to tell the same judge. Ordinarily, you would say, no, you must get someone else to say whether there are prospects of success, not the same one, but it is what it is. That's all that sentence talks about. It doesn't talk about, it doesn't say if there was an application for leave to appeal before this panel, for example, it can now just be heard by one person.
Here's the third point.
Yes.
Now, the Concord went on to say that if the other members of the bench disagree with the decision
Correct.
not to recuse, then they have a choice not to sit with that judge.
Absolutely.
So what would you say, what is envisaged there is a dissenting judgment?
Yes.
From,
Yes, thank you. You've answered the question. But also this, Justice Medina. It is for us, remember, we live in a democracy of transparency. So we also need to know, so does this court, need to know, for example, whether Justice Homo or Advocate Gabriel SC agreed or did not agree. It might have been a 2-1, it might be a 3-0, we don't know because of the formulation. But here's the catch. There's always a catch in this thing. You must, I implore this court, go and read the decision of the recusal of Semenya SC. Same procedure. You will see that even though it's signed by the chairperson, everywhere it says the commission says this, the commission says this, the commission finds this, and the commission. Go to our recusal document. It says I say this, I say this, I say that. So neither the court nor us are none the wiser as to whether the other two, how can that be? Yeah. Yes, how can that be legal? And so that's the panel point. The second point, which is related to that, is the properly constituted. If a board of directors makes a decision, you need to know that it was properly constituted. Because if it was not, that decision can be thrown into the dustbin.
yeah, and if we are with you on this point,
That's the end. We go home.
I wonder what's taking home is
Sorry. I'm sorry. That's sorry, Justice. Yes.
maybe
There's something waiting for you. Yes.
So my question to you is that if we are with you on this point,
Yes,
there
Justice.
isn't a proper ruling on the recusal application.
Yes, there's an illegal one. Yes.
There isn't a ruling.
Yes. No. Yes, the issue. the rule about I don't have my hookster here. The rule about proper constitution of a panel works like this. There is I'm going to be the DG of this and the other, and the rule says that there must be a panel of 3 people,
Yes.
and then the decision is given by 1.
Yes, the commission is not properly constituted.
Yes, that means the commission is not properly constituted. In other words, the decision that was given by the chairperson is invalid.
Yes.
But the
And
chairperson.
what would the appropriate remedy be? That's where I'm going.
Yes.
The ruling would be, the ruling of the court.
Yes.
Would be that the ruling in respect of Justice Khampepe's recusal application is invalid.
Correct.
What would be the appropriate remedy?
Well, it's to uphold the application, because what we are saying is that there's a list of legal grounds upon which the invalidity is based. One of them is section, I think it's 62E Roman 3.
Yes, I'm asking you on the remedy, the consequence.
Yes, but you can't have a remedy without first the finding. The finding is that.
I'm with you on the finding. If I'm with you on the finding, what should be the just and equitable remedy be?
Yes. Well, if you allow me, please, to address this question. I'm saying if you find, as you postulate, that section 62E3 was breached, the one that says a decision is taken by an unauthorized body and so on, then the remedy lies in section 8 of PAJA, if you find for us on the PAJA grounds. But if you find for us on legality, then the remedy lies in section 172(1)B of the Constitution. I just wanted to make that distinction. Remember, at this stage, we have not yet, the court has not made a choice whether it's a PAJA review or legality review. So that's why I'm answering the question like that. So it's either section 8 or section 172(1)B.
To suggest a practical, just and equitable remedy. Does the application then is related back?
No.
What should the remedy be?
The set aside.
Yeah,
It's there in paragraph 2 of the notice of motion. Then
so we simply set it aside and that's the end of the matter?
No. You do 2 things, Justice. One is to declare it to be invalid in terms of 62E Roman 3, and don't take me to task. I might be finding the Roman, might be, but that one of ultravirus, the ultravirus ground or rather, then that's why we say review and set aside. That formulation, people just throw it out, but it actually gives 2 remedies. One is to review, the other one is to set aside. The just and equitable part of that, the section 8 part, is the setting aside. Okay, so that's the remedy you give. And then in some other paragraph we say you can give any other just and equitable remedy that suits the court. But the primary remedy is simply setting aside, review and set aside. Okay. Now, sorry, Justice Mutawa, you wanted to ask a question?
Yes.
Yes.
Leads me to the next question, which is closely related to what my sister asked.
Right.
Does that invalidate the appointment of Justice Khampepe as the chairperson if that decision is set aside?
No, absolutely not.
So you won't be going home anytime soon then?
No.
Then she remains as the chairperson.
How can she remain, Justice? The 2 things have nothing to do with each other. The appointment, the invalidation of the appointment is one thing. The decision, then, let's call it the non-recusal decision, that's what brings us here. It's not the appointment, it's the non-recusal decision. If the non-recusal decision is set aside, what is remains? Recusal decision. Okay. So, well, if the non-recusal decision is unlawful and invalid, all you are saying in simple legal terms is that the decision she should have reached was to recuse herself.
Can we be directed to the
notice of motion? Yes. You'll find that in, sorry.
Once you are looking for a page, I want to remind
Yes,
you
I'll listen.
that we are
In-
already 5 minutes into the lunch.
Oh yes, yes,
Yes.
yes. I'll be mindful of that. Sorry, I'm just -1 003-1. Sorry, Justice Modiba. And you've been directed.
Maybe I should ask the question differently. Look at prayer 5.
5. Yes.
What happens to that reading?
No, you're not reading the amended notice of motion.
Well, I'm reading the one I've been directed.
003-3. Yeah, it starts at -1, but -3 is the notice of motion. Amended notice of motion. Remember, 00-3. Are you there? Yes, you have been directed to the correct one. The paragraph 5 deals with whether the Mbeki applicant.
Recognition of the
Yeah.
of the
So that's the wrong paragraph. Which maybe you can tell me which paragraph you intended to refer to.
So I was saying if I'm with you on that point,
Mm-hmm.
prayer number 2 would stand to be granted.
That's the one. Yes. Thank you.
Prayer
That's
number 3 would stand to be granted.
yes.
Alternatively, prayer number 4.
Correct.
What happens to the rest of the reading?
No, that would be the end. I don't want to say the words, but
My
the
brother raised is that if we set aside the ruling
yeah.
refusing, where she refused to recuse herself, she remains.
No, but how can that be? I mean, how can you set aside her decision not to recuse herself, but she remains? I don't
Does
understand
it not
that.
mean that the recusal application is still pending? There's no proper judgment
No.
or ruling that was given
No.
because it was not co-signed by the other commissioners.
No.
Is that not the issue that
No.
you wanted to go home?
No. Not me.
No.
The person who wanted to go home is the person who appointed her, the
You are
president.
representing that
Yes.
person.
Yes. Yeah. No. The answer is I don't. All right. Paragraph 2 says declaring the conduct of the first respondent in dismissing the application for her recusal to be unconstitutional and invalid in terms of section 172(1)(a) and 38 of the Constitution. That's the declarator. But then that goes with the granting further and alternative equitable release and so on and so on. But Justice Modiba actually was taking it nicely because it then says directing the first respondent be removed from being a member and or chairperson of the commission. So I don't know how she can remain after that. And then declaring all acts and directives and so on. Yeah. So if you go at prayer 6, it's as clear as anything that directing the first respondent be removed from being a member and or chairperson of the commission. All right. Let's leave that for now. I don't think I can take it any further.
Yes, you've got a minute to wrap up. It's long
before lunch, yes.
There are
Yes.
other things that require my attention.
Yes, no, I apologize. I just want, yes, at least we've done those E1 to E3. So that's a natural point. Let me just explain what I'm going to do when we come back. I'm now going to address you, excuse me, on E4 to E8. That includes the Section 47 thing, the in media res, separation of powers, and all that, all those things. Those are the Mr. Ngokaitobi's preliminary issues. And then, as it happens, as we're having this debate, some of the issues on the merits, like this one about the proper constitution, have been disposed of. So I'm not going to go back to those issues when we deal with the merits. I'll assume that the court has heard what I have to say, in the sense that, which is why the court made the ruling it made. Some of the so-called points in limina are in any event intertwined with the merits. So it's a correct point at which you intervene, Justice. Yes, of course.
We are adjourned for lunch. Until 2.
You're still going to argue the recusal?
Yes.
Done.
Yeah.
The newspapers, we haven't had the newspapers.
No,
They're coming. They're coming. I know you like. They wanted the WhatsApp. I want the
and in any event, there is not a jurisdiction. That's a procedural. Yes, exactly. Objectively, the court has jurisdiction. Then, as far as the media arrest, it's clear that they must also be, because they must imagine themselves saying that yes, it's and then the litigants coming and saying well, she wanted to understand how they get there, because I think they wanted to get it here. If they find a reviewable doesn't follow the
Well, we already are sending you two.
You should see me now. Yeah. This is us.
Are you guys staying?
No, we're gonna go to lunch.
you're going to go there.
How are you, Snake? Sure.
But I'll remain because of the gadgets. You guys go.
But I'm sure there will be.
Are you gonna leave? Some of our colleagues will stay behind. Loud and clear, Gareth. Are you starting with me or starting with the guest? Perfect. They're going to come to us after the guest. No? We don't have a guest. No. Studio guest.
In other words, we could say, we'll fold our arms, we'll wait, and if she makes some finding against us, then we will. But if she doesn't, it's fine. You're not allowed to do that. Once you know a ground, you must go to court there and then, it says. Litigation must be brought to finality as speedily as possible, obvious. It is undesirable to counsel parties in litigation to live with the uncertainty that after the outcome of the case is known, there is a possibility that litigation may be commenced afresh, because a late application for recusal, which should have been brought earlier, to do otherwise would be to undermine the administration of justice. I don't have to explain that. I think the court is clear. And then we say that, further underscore the exceptional nature of this matter, we say that what would be more extraordinary than a situation in which a chairperson of a commission refuses to recuse herself, even after the president who appointed her, acting through the Minister of Justice, has formally requested that she step down. The chairperson's refusal to do so demonstrates that she has effectively embarked upon a frolic of her own in revealing a personal and one-sided vested interest in the matter. This conduct renders the present case not merely exceptional, but singularly so. So what we're saying there is that forget about the law for now. Just the pragmatic thing to do, if the person, you can't say, if I go to Mr. Maineche and I say I want advice from him, because remember, a commission is nothing else but an advice. I always say it's a glorified DG, because you are going to give recommendations to the president and he may do nothing about it, unlike a court of law. If I go and ask Mr. Maineche for advice, Mr. Maineche, being the brilliant lawyer that he is, I'm entitled to say, Mr. Maineche, I no longer want your advice. I just don't want it. He can't say, no, I'm going to advise you whether you like it or not. That's just... So, it's a grave injustice to do something which is destined to go to the dustbin, basically. So, thirdly, we say the defense must be rejected simply on the basis that, on its own merits, this is very important, judges. Let me explain this. The defense of in media res, let's now say it's good, only goes to midstream reviews, right? So let's assume it's good. Then it will only dispose of the review part of our case. It doesn't feature in the declarator. Now, so it's just a waste of time. It's a merry-go-round. Assume it's a good defense and it gets rid of the review ground. It's not dispositive of this matter, because this matter can still be decided A, on the declarator, and B, on that other relief against the president. So it doesn't go anywhere. Separation of powers, I'm not going to deal with it. I don't think it's being pursued seriously. I don't think anybody seriously wants to tell us that if we are... Remember, this one just goes for the president's relief, not the other. So what they are really saying is that if we're saying the president must act in terms of the terms of reference and all the things I was debating with Justice Park, then we are encroaching on the executive. But surely that can't be the case, because what you are saying is that the president, I don't even know how to phrase this, he says himself, I would not have appointed her if I had known these things that have now been revealed in these papers. So if you like, I don't know how to coin it, you call it a retrospective irrationality. So he's saying, if you place me in that place, I would not rationally appoint her, because I now know these things. Now you can't blame the president for that, because he's saying I was not aware. And that is why my learned friends for the commission and the Kalata group, which the court must really underscore, are forced to hurl insults at the president, because they can't come out of that. So then they say, no, he's lying. He must have known that she worked for the NPA and the But how can you say that? Just like they say even about us. So the president of this country puts under oath, he says to this court, I was not aware of these things. I've now become aware of them, and I would not have appointed her. And the other side says, no, that's not true. On what basis can the court make that finding without cross-examining the president, that he has perjured himself before this court? He has not. That finding can never be made. The court has to accept that the president was not aware of these facts. The court, just as the court has to aware that former President Zuma and former President Mbeki were not aware. I don't know how many, nobody can say that. I used to work in some place, and if somebody says to me, oh, I forgot that you once worked there, I can't say, no, but you must remember. Everybody knows it. It can't be. We don't sit here worrying about this person or that person's history. There's another person whose name I won't mention who used to work for a very important institution. And some of us forget that he was once in that important institution. Again, will remain nameless. It's natural. So you can't say, no, but you're lying, Mr. Mpofu. You remember. You have to remember. You know? So that's the one thing. Now, at what point do you then say, no, this court must insist that this advisor must continue despite, it's like a marriage, it's one of those relationships which cannot be forced. If one of the people, the advisor and the advisee says thank you, it's thank you. You can't say, I want to be married to you, Genkan. Now, so abuse of process is also, I'm not going to deal with that. There's no abuse of process. I mean, if a party is aggrieved by a decision of a functionary, they are entitled to come to court. I don't know where the abuse of process is. Then comes this one, and this is now, we're now moving towards the merits, back to the merits, justices. Because like I confessed with my third point, this one, although it's put as a point in limine by Mr. Nkhaitobi and the team, it actually deals with the merits. And it is the unreasonable delay, so-called, and unconstitutional conduct. Now, this is the most, with the greatest respect, myopic ground of review or of opposing our grounds of review. I tried to read this thing 10 times and I wasn't sure what is being said here. Are they saying that we have unreasonably delayed in bringing this application? We should be ridiculous because we didn't. The decision came on the 30th of January and we were in court by the 6th of February, less than a week. So surely that's not what they're saying. Or are they saying when Justice Khampepe found that on the basis of undue delay alone, she could dismiss the recusal application, then we are wrong about that. And I'm sure it's the second, because the first one is out of here. So if that is the complaint, then we say the following, at least, and I'm not speaking for former President Zuma, that accusation was completely unwarranted, irrational, and unreasonable on the part of the chairperson of the commission. Why? It is common cause, justices, that, you see, what they do is to exaggerate the time. They say, well, these people waited for 8 months. And then in another part, they say they waited for 6 months. Let me tell you how they do that. The 8 months doesn't even work. They say it's because the commission was promulgated in May, and then you brought your application in February, which is 7 months, by the way. Then that is the period. But that's not the period. Then elsewhere they say, no. President Zuma, we sent him the rule 3.3 because we say, how are we supposed to know? They say we sent the Rule 3.3 on the 19th of September.
The notice you mean?
The notice, 3.3 notice, thank you, Justice. We sent it, they say, on the 19th of September. So suddenly, you do away with the so-called 8 months. So now we're talking 3 months or 4 months. But even that is fallacious, because we say it's common cause. They've admitted. We say former President Zuma wrote a letter to the chairperson, to the secretary, and said on the 2nd of October, nothing to do with September, says, I've received this document, I'm traveling overseas, I've given it to my lawyers, I can't even consult on it, I will deal with it when I get back. Please, Commission, give me an extension. I think the deadline was the 8th or 18th of October.
And that was granted?
It was granted. So we can forget about that. So that's another month gone from the so-called 2 months. So now what are we left with? 2 months. Then in November, President Zuma says, I've now write a letter on the 3rd of December. Says, I have now, thank you having asked for another extension. I've now consulted, these are the words in the letter, I've now consulted with my attorneys and I have these complaints. I want the chairperson to recuse herself and so on and so on and so on. And the chairperson issues directions to say you must file papers by such and such a date. Nothing wrong. So I don't want to testify from the bar, but from that you can read that when he says, he actually says, I have now consulted. So I could take advantage and say that consultation happened on the 3rd of December. But as counsel, I have to be honest with the court that those consultations had occurred in November, actually. So let's say it was in mid-November or some time at the beginning or the end, it doesn't matter. The point of the matter is that the 2 or 3 weeks between that date and the 3rd of December can never be taken as unreasonable delay. So it was illegal, unreasonable, and irrational for the commissioner, knowing what she knows, having been the one who granted us the extension, being the one who granted us the directives, and we acted according to her directives, to suddenly say, oh no, but you had 9 months or 8 months or whatever. There's just nobody who has read these papers can come to that conclusion. And therefore that decision must be kicked out completely. But what is more, and this is the startling part, the way she formulates that decision, Justices, is she says, this is paragraph 100 of our heads. We say, in this regard, the fatal mistake made by the chairperson was to uphold the defense of unreasonable delay on the basis that, and I'm quoting here, even if I am wrong in the conclusion that she had made regarding disqualifying bias. I mean, what is that? In other words, she's saying, even if I'm wrong and there was actual bias or there was unreasonable or reasonably apprehended bias, I can still kick you out on the basis of delay. That cannot be the law. That in the face of the most egregious constitutional breaches proven, even if I'm wrong, you can then say, oh, but you know, you took 2 weeks to do this. So that point must, on that alone, by the way, I don't want to use the expression I used in the morning because it's clear we're not going to go home very soon. But on that alone, that she said that she could do this on the delay alone. Put aside the questions of the Gijima principle, which says that you cannot do that anyway. The Gijima principle says that even in the face of delay, an injustice, a clear injustice, cannot be defeated by delay. And remember here, we're not postulating a situation where the clear injustice has not been proven. She says even if that injustice has been, even if I communicated, even if I sent emails and WhatsApps and all that, I can just kick you out on delay. So then we then go to the the rest of the merits, let me put it that way, because we've covered most of the merits. The declaratory relief, I won't waste time of the court about it. It is self-evident that if these things that I'm saying have happened, where email exchanges that have been done and all that, the Section 34 rights, at the minimum, forget about everything else, Section 34 rights of my client would have been breached. Or as you know, in Section 38, it even makes it lighter. It says if those rights are infringed or threatened to be infringed, which goes back to your question, Justice Midao, about finality. We know that the Constitution says even if the rights are just threatened to be infringed, you can get a declaratory relief. Then let's go to Section 9. Section 9 is very simple. Section 9 is that everyone talks about all are equal before the law and the benefit of the law and what have you. Now, again, postulate a situation where, as we say, there's an admitted secret discussions and all these shenanigans that have happened. Thank you. And for that, I want to just refer the court to one. There are many, but I'll just refer you to one. To one example of why we are as bold as to say that, if you read the papers, the illegal exchanges of communication are actually admitted. The official spokesperson of the commission, forget about the KG responses, the non-committal responses of Advocate Semenya, who should know, by the way. Remember what the chairperson says in her ruling. She says, I don't know why these people are questioning why Advocate Semenya is the one who did the affidavit before me. Because after all, they are the ones who are accusing him of having colluded with me. Now that would sound very sensible, except if you go to that affidavit, Advocate Semenya says zero about that exchange. So if that was the reason, then why is he not dealing with it? So that's the first. Then I'm sure if this person, I don't know if they still work there. If I was the chairperson, I would have gotten rid of him by now. But here's on the 6th of January, on a television interview in Newsroom Africa, just after when this whole thing was hot, the official spokesman of the commission, it's 077-95. The commission, Mr. Lionel Adendorf, while being questioned by the host, Mr. Kolim Gambi, on whether the chairperson was perturbed by the allegations, our allegations, replies as follows. I'm quoting. She's an amazing person. I spoke to her earlier, underline that. In other words, with this hullabaloo of these allegations, I spoke to her, not to somebody else. And I just want to make reference to where she advised the chief evidence leader on the matter. She does that to me often. She does that in the normal course of our work where we talk regularly about things, and there's nothing wrong with that. She's not concerned about it as well. She's not concerned at all. So what is he saying? This is the typical confession and adverse. He says, yes, she did, but there's nothing wrong with it. That's a different thing from saying, what are these people smoking? What are they, sorry, what are they talking about? It's
tone down the language.
Yes, no, of course.
We live in a country where respect is fundamental.
Well, it was not, anyway, that's fine. I apologize. The point I was making is simply that the normal reaction of a person me, you, everyone else, whether they are in whichever country they live in, who's faced, there's a court case about this, there's a criminal case, by the way, but I won't share the amusing effects of that. But it's as if somebody accuses you of X and you just look down. Instead of saying, no, you're talking about me, then you know. But anyway, the point I'm making is that here is an admission made by the official spokesperson who says, I spoke to the chairperson, and she says, yes, this happened, but there's nothing wrong with it.
So you're about 12 minutes away from the time that you...
Yes, I'm aware. Yes. Yeah, I was going back to make a deal, but it might be premature. So, the declaratory relief, by any stretch of the imagination, has to be granted just on the admitted facts alone. Even forget about the fact that we haven't had proper discovery, the record is not properly before the court and all that. On the pleadings themselves, the admissions are telling. Let alone if the court finds later, which I suppose is a theoretical possibility, that we were entitled to the full record, in which case I wouldn't be debating this. I would simply be saying, are these the activities of a fair chairperson? But that will happen in another day. Now, we then refer to the case of S versus Roberts. And you'll find that at 115. The case of Roberts says specifically, I'll paraphrase for Roberts says that at paragraph 23 of that judgment, that it is never allowed for the decision maker, I don't have to repeat this to the court, you do this all the time. It's never allowed to confer only with one of the parties about a matter if it's an adversarial matter. You must disclose to the other party, and you can only deal with that other party, with the one party, when the other one is present. Sorry, I'm sorry, Justice. Yeah. So that case says, and here's the retort. They say, oh no, this is another stunner. Instead of saying, no, this never happened, they say, no, but the chairperson and the evidence leader, they speak all the time. But that's not the point. We know that they speak all the time. The point is, did they speak about this subject of advising the one person to say, you must watch out for paragraph this and paragraph that, and you must, this is how you, we've done some research as the panel, and here's the research. That's not about we speak every day. Of course they speak every day, but that's not the question. The question is, did you have this particular discussion? Why? Because it doesn't avail, my learned friends, to say, no, but commissions, the point earlier you raised, Justice, which I answered, to say, no, but it's just a commission. It's inquisitorial and what have you. So that means now fairness suddenly doesn't apply just because it's inquisitorial. Let's assume it is. But here's the real point, Justices. The commission itself is inquisitorial. We will be the last ones to quibble with that. But the recusal application we're talking about was adversarial. The NPA and the Minister of Justice adversarially made certain accusations, true or false, against my learned friend Mr. Semenya, and therefore that self-contained adversarial process was taking place. Now, in that process, you can't then say, I'm going to advise one of the parties and not the other, or talk to the one party against. Everyone knows that. So a trained judge, or not even a normal person, will know that, well, for the purposes of this thing, there are certain things I can't do. We can talk later, but I can't. And the example is S versus Dube. I think one of the parties has referred to it. It's a famous example of Justice Mogoeng, who famously and admirably recused himself from a case in the Northwest simply because his wife was the prosecutor. And the other side said, well, you know, there's a reasonable apprehension that, and Justice Mogoeng said, look, I know as a trained judge that I can't discuss this matter with my spouse, and I didn't. But he said, I'm going to recuse myself because a reasonable person in the position of the accused in that matter has a reasonable ground to perceive that there is something not going on. And that's the test. Another example, we've cited the case of S versus Zuma. It's a famous case of Judge Kuhn. Judge Kuhn in that case, I'll give the reference. Judge Kuhn in that case said, look, I made a finding in a previous case about a prosecutor, which was favorable to him. Now, a situation that nobody could have predicted has arisen where the title of that prosecutor to prosecute, or the fairness, is being challenged. I can't be the same person who's going to make that determination. And this is the part, and I will find, in reply, I'll give you the specific passage. It's a long judgment. It's one of the best judgments on recusal, because it traverses all the cases from Roberts to Sarfu to Sakau. It's 055A-435. But I just want to bring the court's attention without reference now to this. He says, and this actually covers what Mr. Manecha will be dealing with. He says, Mr. Mpofu, meaning me, did not argue that, and that's why he shows the distinction between actual bias and reasonable apprehension. He says, had Mr. Mpofu argued actual bias in this case, I would not have recused myself, because I know that the mere fact that I gave that judgment doesn't mean I'm now not going to be fair, as a matter of fact, which was true, and that's why we didn't argue that. But he says, when once the issue is about a reasonable apprehension of bias, then I have to recuse myself. So that's where these respondents don't understand the difference between actual bias and a reasonable apprehension of bias. So in which world let's assume the actual bias is not there, let's assume the emails are not there, let's assume all that. In which world does a former President Zuma, being told by a whistleblower, which is common cause, that these shenanigans happened, and he must just say, oh, well, I trust in the system. It's the most unreasonable expectation of any human being. None of us would be that holy. It's because you have to say, no, it's not true that he got this message from the whistleblower. That's a different thing. But that's not what they are saying. They're saying, yes, he did get the message, but it was unreasonable for him to...
If I may, Mr. Mpofu,
yes,
you made reference to this decision by
Robert
Mogoeng J. Sorry, I'm taking you back.
Mogoeng J, yes. Thank you.
There was a special entry.
Yes.
He had not recused himself.
Yeah.
There was a further appeal.
Yes.
And it is then that he granted leave to appeal.
To appeal, yes.
Yes.
But
so he had not recused himself. That was the issue. He had said in the
well, Justice, I beg to differ with that interpretation. I will refer to anyway, I don't want us to be bogged down. I'll deal with it in reply. But the point is this. If you read Justice Mogoeng's judgment in the CR17 case, I'll give you the reference of the CR17 case. In the CR17 case, Justice Mogoeng actually makes reference to that his judgment in Dube. And where he says the president should not have been the one to determine this whole CR17 story. Because he says, he makes an example about himself where he had to recuse himself. But I'll give you the passage in the it's called Public Protector versus the President. Yes. So it might have come as a special entry and all that. I'm not disputing that, Justice Mudau, because I don't have the facts on my fingertips. But the point I'm making is that it was found, okay, let's say it was not found by him, it was found by someone else, but it was found that the real point I'm making is that the mere reasonable apprehension of the fact that he was living with his spouse and he may have discussed it was sufficient to that's really the point I'm making. I stand corrected on the facts and I'll deal with it in reply. But and in any event, the example of Justice Kuhn applies in the same way. Because remember, Justice Kuhn also had the proper Latin is sua sponte, had raised this question and asked the parties to address him, and we had our heads of argument, and Mr. Tsolikov, I think, had his. Just the example, the quotation from Roberts, which I referred to earlier. It says, that justice publicly be seen to be done necessitates as an elementary requirement to avoid the appearance that justice is being administered in secret, that the presiding judicial officer should have no communication whatever with either party except in the presence of the other.
Where are you reading?
I'm reading from, you'll find that,
The exact reference where you read.
yes, you'll find that it's a preamble to the heads in the recusal application, 077-744, Justice. 077-744, where that case is quoted. So to round up, because this is the moment where I'm eating into Mr. Manecha's time. It matters not. It matters not that I'm not going to get into that debate whether PAJA applies or not. We've put our submissions. The court will read them. We have said that the question is not finality, as my learned friends put it. The question is whether the decision has a direct legal effect. Those are the words in PAJA. And it has been said that for a decision to have a direct legal effect, one of the issues is that it must be infringing on the rights or threatening to infringe. So it's clear that PAJA applies, because that's the only objection they have is on the direct legal effect. But let's assume we are wrong about that. So what? Because the alternative ground is the principle of legality, and everybody accepts that the principle of legality applies. And everybody also accepts that all those shopping list requirements in PAJA, well, maybe not all, that might be an exaggeration, but the majority of those 6.2 of PAJA are equally applicable to, including this one of actual bias, by the way, which is 6.2a Roman 3. 6.2a Roman 3 of PAJA says that the decision must not be actuated, sorry. I'll just read one example. The rest of the shopping lists the judges will look at in their own time. So 6.2a 3. So a court or tribunal has the power to judicially review an administrative action if the administrator who took it was biased or reasonably suspected to be biased. So the whole thing that we are talking about of actual bias, was bias means actual bias or reasonably apprehended to be biased. So whether you do that under PAJA or under the common law or under the legality, the result is the same. So that's a non-debate. Now, on costs, I have to say this. By the way, just to tie up, what I've just said now applies to all the things we discussed even this morning, whether there's is ultra-virus, whether she took into account irrelevant considerations and so on. You'll find all of those things in that shopping list, and we make those points in our founding affidavit. And by the way, they are not answered. You'll find that in the answering affidavit, none of those is dealt with, where we say these are the departure grounds and we develop them, why this one was breached, nothing. So there's no basis upon which this court can reject our departure grounds, either as departure or as legality. Now, costs. In other words, what I'm saying, Justice, is that the declarator must be given, the review must be given, whether it's under departure or legality is neither here nor there. And then the consequential relief must follow. Now, on cost, I have to say this because I don't have time. You don't have to go anywhere than the decision of none other than Justice Khampepe in the case of Public Protector versus SARB, South African Reserve Bank, 2019-6 SA 253, to find the most brilliant outline of how it is that bias attracts personal and punitive costs. She explains there two things. One is that you need to be candid in the context of what we said in the morning. In the Rule 53, you must disclose everything and not play cat and mouse. Two, that even though the other side there had said, no, but you are confusing bias and Audi. If you didn't, let's say you closed off the other side, the NPA in that issue, that's an Audi question. They should have been there. She says, no, Audi itself can lead to bias. I think it's at paragraph 185.
I'm trying to go to the citation, 2019-6.
2019-6, Justice,
yes.
SA 253. 0558-93. And you'll find the passage I'm talking about at 185. Remember, there's a judgment of Mkhweng CJ, which went the other way. And then the majority judgment of Khampepe J starts at paragraph 131, and I'm referring you to 185.
Well, I'm on the judgment.
185, Justice. It says he says the public protector was, however, required to produce a full and complete record of the proceedings under the review in terms of Rule 53 of the Uniform Rules of Court. This included, quote, every scrap of paper throwing light, however indirectly, on what the proceedings were, both procedurally and evidentially. An essential purpose of this obligation is to enable a court to perform its constitutionally entrenched review functions. This gives effect to the rights of parties under Section 34 and so on and so on. And then she says, because of that caginess and the failure to give every scrap of paper, which is exactly what she has done in this matter, punitive costs and personal costs against the public protector had to be done. If you read that judgment, you will see that Justice Khampepe understands, and that's aggravation on its own. Because it's one thing for someone to do this, what we are accusing her of in the Rule 53 thing, when they don't know. They're just a person, some clerk and he says, well, I didn't know I had to produce a Rule 53. Here's someone who, by their own mouth, was saying that this is something to be deprecated, number one. And then there's another passage, I don't have I'll tell you that in reply, where she says, the mere fact that you don't, in your answering affidavit, you don't give us a clear answer. You are here and there, and this was about meetings that were supposedly held with the president. Same thing that we're talking about with Advocate Semenya and so on. She said, if you didn't have the meeting with the president, just say so. And if you don't say it and you give us all these long stories, that is the reason to give punitive costs. That is exactly how she has behaved in this matter. So, if you like, you can say, then she must have a taste of her own medicine, and she must practice what she preaches, because the point is simple, that for that kind of conduct, it is true what she said, is not to be countenanced. And she says there's a higher duty on people like the public protector, and I dare say, if there's a higher duty, which is why she imposed those punitive costs, that duty is even higher for someone who has held judicial office. It can be less than the public protector, with the greatest respect. It has to be even higher. If there was something more than punitive costs and personal costs, we would be asking for it. But unfortunately, there isn't. Thank you.
Yes, I'm just thinking it aloud. Perhaps we'll hear from your opponents. Which
Yes.
that way Section 47 kicks in.
47,
the one that...
No.
Oh.
Let me, yes, that's a good question. Thank you, Justice. Yeah. No. You see, there's a difference between, and that's a mistake that can be made. We are not here saying that the maxim that says, what you call it, the judicial cloak of office goes with you to the grave, should go away. No.
I thought we were judges for life.
Yes, that's what I'm saying. That the life means the grave, yeah. That's what I'm saying, yeah. So, no. That's not what we're saying. What we are saying is something completely different. We are saying, as a judge, if you are cited, you are bound, by the way, in this respect. Thank you for raising that, because I had forgotten the point. The case of Corruption Watch binds you in this respect. Paragraph 4 of Corruption Watch. There is the case, I call it, it's one of those rare cases. It was the case of the JPs. You remember you had 3 JPs sitting in that case. JP Mlambo of this division, JP Davis,
Yes.
and JP Leo
Of the Northwest.
of the Northwest. Yeah. So it's as good as it gets. And this is what happened. Okay, I'll paraphrase. If you go to paragraph, and Mr. Manager might deal with this, paragraph 4 of that judgment, it says, it's the Justice Siriti is Justice Siriti and Justice Musi, who are cited in that case as respondents. And the court said they were cited in their non-judicial capacity. That's the issue, Justice Mudam. And so that's why that relief was granted. Because, I'm sorry, just give me 1 second. I apologize, Mr. Manager. Yeah, Mr. Manager has borrowed me 5 minutes.
No, I'm not.
Yes, it might be 8. Let me. Okay, because of time, I'll give the proper reference. Let me paraphrase to save time. Justice, Justice Zuma, yeah. Former President Zuma pleads in his anyway, we'll get there in reply. This is the point. The citation in this matter, in this particular matter, of Justice, you'll find at 001-13, actually 12. Oh, it is paragraph 4. Well, okay, I thought I was wrong. Yes. No, it's the one that says security. Yes, paragraph 4. Is it paragraph 4? Oh, I see, maybe it's the wrong corruption watch case. Yes, yes, okay. It is paragraph 4, sorry. Yes, well, it's my fault. I'll give the citation. This is the corruption watch case where the decision of the Arms Deal Commission was set aside. That's the one of the 3 JPs. I apologize, Justice Mutiba. It's not the normal corruption watch, the one of Masana and all that. 056-286. You'll find it there. In paragraph 4, there says, okay. Anyway, the point I want to make, the citation of those judges was exactly the same as in this case. Because we say at paragraph at 001-12, the first respondent is Commissioner Sisi Khampepe, who is a retired judge. So that goes to the Madlanga Benenge issue. And former Constitutional Court Justice. At some relevant time, she held high office of whatever acting DCJ. She was subsequently appointed a judge in several courts. Here's the catch. See, she is cited here in her non-judicial capacity as the chairperson of a commission of inquiry appointed by the president in terms of section 82.4. If you go to paragraph 4 of Corruption Watch, the correct Corruption Watch, it says, the second respondent is Justice Willie Lehwabe Seriti, NO, who is cited in his capacity as the chairperson of the commission. Exactly, that's why we pleaded this like this. The third respondent is former Judge President Hendrik Musi, who is cited in his capacity as a member of the commission. And then they say the other. So that formulation, which was accepted in Corruption Watch, is what is binding, not this thing that you are bound by Mantashe. You are bound by the full court on Corruption Watch. Thank you. I had forgotten that point. Thanks for asking the question, Justice Mudau. So the fact that you are a judge for life doesn't necessarily mean just everything you do in the church or everywhere is you must now go to ask for permission from the JP.
Is that it?
That is it. Thank you. I'm indebted to the court for the extra 10 minutes.
No, you borrowed from your friend. We want to extend the time.
Thank you.
May I just clarify that in respect? My learned friend has time in reply. Whatever he eats of his time in the main address, he will pay in reply.
That is if you remind him.
I've got 1 hour 30 minutes allocated to me. What we intend to do is I'll share the time with my learned friend, Ms. Muvangwa. She will address one of the topics and I'll identify the topic.
Justices, I'm prepared to pay back the money.
But that sounds very familiar.
For somebody's client. My lords and my lady, what I propose to do is to first address
Before I forget, where's the draft order?
The draft order is, it's been emailed, uploaded also. Thank you for that reminder. So what I'm going to address, we are going to address the grounds of recusal based on a reasonable apprehension of bias that were raised by in the former President Mbeki's application before the commission. In addressing that case, I'm going to address the following topics. The first, I will make some submissions on the test for recusal, where disqualifying prior associations are alleged, which is the institutional roles, and my learned friend has called it vocational history. As the first. The second, I will deal with the actual review regarding prior associations. We have to satisfy the court that there is a review ground in relation to that recusal ruling in respect of this ground of recusal. So I'll take you to the ruling. I'll identify the reviewable irregularities in the ruling, and I will then make submissions on the outcome of the application for recusal if one applies the correct test, because that leads to the consequential relief which the court debated with my learned friend, Mr. Mbeki. That's distinct from getting to the appropriate relief via the termination of the appointment, but instead via the review and setting aside of the recusal ruling, because the recusal ruling is reviewable for the grounds that we will raise. Then I will deal with the issue of delay. I was going to address the question of whether the commission ruling was handed down by a properly constituted commission. In other words, where it's only handed down by the chair. But I have nothing further to add to what my learned friend Mr. Mpofu has said, and I'm not going to waste the court's time on that. Then I will deal with the various legal points which the commission raises. The first being the Section 47 issue, then the in media res or missed-in review, and the PAJA review. Can I just deal with the PAJA review here and not have to come back to it? It's really an interesting debate, but
is the PAJA applicable? I'm keen to hear.
Well, we could have debate. We've made submissions that PAJA is applicable, but it's a pointless debate because the grounds of review that we raised results either under both under PAJA and under the principle of legality. So whatever decision you make on whether it is PAJA or legality, the ruling remains reviewable before this court, at least nowhere. It would only be relevant if we were complaining about grounds of review which are only available under PAJA and not available under legality. In that case, the court would have to make a determination on whether this is a PAJA review or not. But all of the grounds we raise are legality grounds. So I'll refer the court to where we make our submissions on whether PAJA applies or not. But in the course of my address on the test for recusal, I will indicate why we say PAJA applies, because rights are affected, adversely affected. And that this is a decision of an administrative nature on how the proceedings will be conducted, how the commission must be constituted in terms of legislation. That results under PAJA, but we don't believe that the court need necessarily have to decide the issue. I'll also deal with the question of appropriate remedy and costs. And my learned friend, Ms. Muvango, will address the second review, ground of recusal, which we have referred to as procedural complaints. And she will indicate how the ruling in respect of that is reviewable. So then I turn to the first topic, which is the test for recusal, where disqualifying prior associations are alleged. It's quite important because it will point to the court clearly whether the chairperson actually applied the correct test in assessing recusal where there are allegations of prior associations which are set to raise a reasonable apprehension of bias. Before I do that, I just state a common constraint that both the chairperson and everybody making submissions accepts that the rule against bias applies to commissions of inquiry. And this was also decided in Corruption Watch by the full bench, and we refer to that in our main heads of argument at 054-95 at paragraph 6. So the arguments that a commission of inquiry is not adversarial, is inquisitorial, are all correct, but even despite that commissions of inquiry conduct their proceedings inquisitorially, the rule against bias applied to those commissions of inquiry. There is a right to procedural, an investigator, a fact finder who's going to make findings of fact and make recommendations, that person will do so with an impartial mind. They will bring an impartial mind to bear on the investigation. That's common cause. We will respond to it if it is suggested otherwise. On the test for recusal, we have in the heads and in the supplementary heads dealt with it fully, and the court is very familiar with the double reasonableness test. What we wish to do is to just highlight certain features of that test that were highlighted by the Constitutional Court in Sarfu, in Absa Bank, and by the SCA, also in ABSA versus Arif. And in Dube, which is the judgment that His Lordship presiding debated with my learned friend involving the former CJ. It's correct that there was an entry, there was no recusal, and the SCA had to determine whether a recusal was called for, and said it was. I start with Safi, and here I start at paragraph 10, and the court will find that at 056-560. And I highlight paragraph 10 because of the criticisms that have been leveled against both of our clients about the motives of their application. These are people who admittedly fought for this country's liberation. They were there to set up the TRC. Some of them, it's common, it's a public knowledge, suffered similar losses as some of the victims in the hands of the apartheid forces. And when they complain that all they are asking for is an impartial commission, a lot of motives are attributed to them, that they want to frustrate the inquiry, they want not to be accountable, and they simply want to delay. And what the Constitutional Court had to say at paragraph 10, and this was a unique application, out of the 11 judges, to ask 5 of them to recuse themselves because of prior associations with political parties and the like, and also to leave a lingering complaint against the rest of the court and refuse to particularize and ask that they too recuse themselves, was indeed an invidious task for that court. But this is what the court had to say. Paragraph 10. At the very outset, we wish to acknowledge that a litigant and her or his counsel who find it necessary to apply for the recusal of a judicial officer has an unenviable task, and the propriety of their motives should not lightly be questioned. Where the grounds are reasonable, it is counsel's duty to advance the grounds without fear. On the part of the judge whose recusal is sought, there should be a full appreciation of the admonition that she or he should not be unduly sensitive and ought not to regard an application for his or her recusal as a personal affront. And that, we submit with respect, applies equally to this court, looking at whether it was not appropriate for a very senior ranking justice of this country to recuse herself. There is that level of sensitivity that must be brought to bear, and to appreciate the difficult position in which the applicants, the lay clients, and the counsel before you labor under, which is acknowledged by the Constitutional Court. And the Constitutional Court went on to say at paragraph 30, which is at 056589, it said at that paragraph that a judge who sits in a case in which she or he is disqualified from sitting because seen objectively there exists a reasonable apprehension that such judge might be biased, acts in a manner that is inconsistent with Section 34 of the Constitution and in breach of the requirements of Section 1652 and the prescribed oath of office. We have no doubt, therefore, that the application for recusal raised a constitutional matter, and my learned friend read further about the need to make a collective determination. So, to the Paja point, when you, and the Paja point must be approached on the basis that there is a case for recusal. When the recusal is refused, that continual sitting breaches the Constitution under Section 34 and breaches the oath of office, because that oath of office continues to apply, as the court raised, once a judge, always a judge, until to the grave. And then my learned friend emphasized the need for a collective determination by the bench when some of their colleagues are asked to recuse themselves. So it wasn't simply a matter of agreement amongst counsel, which is recorded at paragraph 34 of the judgment, that the court had to consider the recusal both individually and collectively. The court had said, as a matter of principle, at paragraph 30, that it bore that duty. Of course, it is correct, and Justice, the chairperson referred to that principle in the ruling at paragraph 42 of the judgment 056-598, that at paragraph 42, absolute neutrality on the part of a judicial officer can hardly ever be achieved. And it goes on that we all products of our social conditions. Some would have been activists and the like. All of those enrich the judicial office, then detract from it. But despite this, and you will recall in this case that some of the allegations against some of the judges were relating to prior associations with political parties or with certain individuals, with former President Mandela and the like. And that the court starts addressing at 056-628. This part is relevant to our case because the ground I'm addressing is that there is a reasonable apprehension of bias as a result of the chairperson's former associations, institutional roles. And so the test that the court enunciates is important for this court to apply. So it starts at paragraph 70 to discuss political associations of judges prior to their appointment to the bench, which is the complaint here. And the relevant test is set out at paragraph 76, which is at 056-635. And the court says there that in our opinion, it follows that a reasonable apprehension of bias cannot be based upon political associations or activities of judges prior to their appointment to the bench unless the subject matter of the litigation in question arises from such associations or activities. And it wasn't alleged in that case. So it's common cause that prior associations on their own is not a disqualifying factor. There must be something more than that. And you'll see that the difference between the ruling and the test being applied is that the ruling said there must be a logical connection, and it assessed that logical connection to mean the same questions that the chairperson had to address when she was in the TRC Amnesty Committee and in the NPA must be the same questions that she must address, she's called upon to address in the Commission of Inquiry, and there must be a timing overlap between when the allegations of interference arose and when she was in the TRC and the NPA. And we will submit with respect that that's an application of a wrong test, and that is a reviewable irregularity. That test regarding prior associations was repeated by the Constitutional Court in Bennett versus Absa. Bennett versus Absa. Sorry, it's at 056-107. And here you'll recall the allegations, and can I just backtrack a little bit? In Safu, when the attorney for Mr. Late, or Dr. Late, sent a letter to the president of the court then, the former Chief Justice Chaskalson, he responded and disclosed, made full disclosure of his relationships with the people that he was alleged to be related and all of that. And when but he said in that letter, I'll advise my colleagues who were not in court, he was only in court with Justice Krichler in chambers, the others were not in chambers. He said, when they come, my advice to them will be that they do not write you letters. We don't engage in correspondence. So if you want to bring a recusal application, you'll follow the formal route effectively. But what Justice Chaskalson did was to make full disclosure upon an inquiry. That's the first thing. The second thing is all the judges implicated, all disclosed fully on a statement of facts, the facts relevant to the complaint raised against each one of them, of the five. Because they're sitting in bank, if you're going to decide collectively, I would know
Justice, in respect of one justice, whether there is an answer to the factual allegations or not. So, but the point to be made and to be emphasized is they honored the oath of office, which requires that at the slightest inquiry about your possible conflict, you disclose. You should disclose up front if there's anything that you think might result in any discomfort, which may result in a recusal request, you disclose. Now, in ABSA, there was an allegation against, this was a claim against ABSA Bank. There was an allegation that Justice Kachalia had shareholding in ABSA Bank, and Justice Malan and Justice Kachalia were part of an institute which was established at UJ for finance law, which was established with the initiative of Justice Malan, for which salaries as members was paid for by ABSA. So when the issue was raised, the justices made a full disclosure before the hearing of the appeal itself. And as my learned friend, Mr. Mpofu, read out, what the lay litigant did in that case, the attorney did, was with that information in the back pocket, he decided that they will bide their time because the judgment might be in their favor. 39 days later, when judgment came down, it was not in their favor, then they raised bias. And that's in the context where the court said it wasn't in the interest of justice to entertain that issue of the recusal, because they waited for an adverse judgment when they knew all along that they wanted a recusal because of the disclosures that had been made. But it's important to emphasize the promptitude with which the disclosures, full disclosures, were made, and you will find that they are lacking here.
But the disclosures are also for the benefit of other members of the panel.
Quite.
Who would not have knowledge of or details of those associations.
Quite. Because there's a duty also that if you're sitting as a bench and there is a recusal application against one of you, and that person takes the view that they are not recusing themselves, but the others take the view that you should recuse yourself, because otherwise, from your sitting going forward, the proceedings are irregular. There's a duty on them to refuse to sit with you. So you can't hold back on information that only you know, which have which have an impact on the recusal request. You should disclose. But you shouldn't even wait for that. You should disclose if in your judgment there's anything troubling, or at least when you're prompted to disclose, you should disclose and let clear the air, so to speak. So in ABSA, they had to deal with a shareholding issue, separate. That's a question of an appearance of bias because of a direct financial interest. They found the interest was very negligible. Billions, the shareholding in ABSA, the market cap was too huge, and the like. Then they went to the prior associations, and the court repeated the SAFU test, which I just read to the court, but then went on at paragraphs 78 and 79, and it's always safe to read from the actual text because there's always sometimes you miss a word when you copy paste. But at paragraphs, you'll see paragraph 74. Could you just help me with my printed page cut off the last numbers? It's 056 and then to page paragraph 74. 74 is the paragraph my learned friend read. I can just read it to you because it becomes relevant to the question of delay. It says, in my view, whether a litigant should be allowed to raise the issue of recusal at a later stage despite an earlier opportunity, so they are offered an earlier opportunity to do so, implicates the interest of justice and not waiver. It's important because it's not waiver. By delaying doesn't mean you waive the right to raise recusal. The question is whether it is in the interest of justice to permit a litigant having knowledge of all the facts upon which recusal, knowledge of all the facts, And you'll see that here we're still not knowing some facts which are relevant to the prior associations. having knowledge of all the facts upon which recusal is sought, to wait until an adverse judgment before raising the recusal. Here, 5 appellate judges pondered the judgment for 39 days before deciding the matter and expended public resources in doing so. Kachelia JA was never afforded the opportunity to withdraw from the matter before judgment was delivered. In addition, the interests of justice demand that the interests of other litigants be considered. APSA invested both time and money in seeking a final outcome to the dispute, and it is entitled to one. And he says, it is thus seems to me that in our law, the controlling principle is the interest of justice. It is not in the interest of justice to permit a litigant, where that litigant has knowledge of all the facts upon which recusal is sought, to wait until an adverse judgment before raising the issue of recusal. Litigation must be brought to finality as speedily as possible, and an outcome must be known. I digressed. I wanted to complete the test on delay because when I come back today, I don't need to read these paragraphs to the judges. What I wanted to take the judges through is the question of prior associations, and it is paragraph 78, which would be 056-143. And so at 78, this is what the court says. Prior association with an institution cannot form the basis of a reasonable apprehension of bias unless, and quotes from Safu, unless the subject matter of the litigation in question arises from such association or activities. Most judicial officers would have been engaged in a number of activities in pursuit of their professional lives before their appointment. These activities contribute to the expertise that judicial officers bring to the bench. What is required is that judicial officers should decide cases that come before them without fear, favor, or prejudice, according to the facts and the law, and not according to their subjective personal views. Of course, where a judicial officer in his or her former capacity either advised or acquired personal knowledge relevant to a case before the court, it would not be proper for that judicial officer to sit in that case. And then they say there is no suggestion in this case that the subject matter of the litigation arises from the association which Kachelia and Malanje JA had with Absa Bank prior to the appointment to the bench, nor is there any suggestion that in the course of the association with Absa Bank, the 2 judges of appeal acquired personal information that was relevant to the appeal before them. So to apply the test to the present case, the question you will ask yourself in respect of the first leg of the test, which is, does the subject matter of the litigation in question arise from such associations or activities? You'll ask the question, does the subject matter of the inquiry, or even the inquiry itself, arise from any of the associations that Justice Khampepe had in the Amnesty Committee and in the NPA? And we will demonstrate that there is an arising there. Recall that the only reason you have the Commission of Inquiry is that the Amnesty Committee made determinations that certain applicants for amnesty were denied amnesty. Those applicants were then to be prosecuted or stood the risk of prosecution. And the same Amnesty Committee sent a list of cases for prosecution to the NPA. You will see from the facts common course, Justice Khampepe was part of the decision maker in the Amnesty Committee refusing applications for amnesty in respect, for instance, of the ANC 37 leaders, who include both my client and former President Zuma. She was also part of the decisions to refuse amnesty in respect of perpetrators against victims whose families are appearing before the Commission as interested parties, because that's how they're identified by the terms of reference. That's 1998, 95 to 2001, she's in the Amnesty Committee. At the same time, overlapping with that time, she is in the NPA, 1998 and 1999. In 1998, the NPA receives the list of cases that must be prosecuted, and the NPA start laying the groundwork for that prosecution. So the NDPP then is Advocate Bulelani Muka, and the deputy, his deputy is Justice Khampepe. So that's the work they're doing. The reason you have the commission is that the NPA has failed to prosecute those cases. That's the reason. That's the cause of the commission of inquiry. If there were prosecutions of those TRC cases, you wouldn't have a commission of inquiry.
That's common cause, is it not?
It's common cause, yes. And in that inquiry, some of the people that she denied amnesty to, former President Mbeki and former President Zuma, are accused of being the external reason for the failure by the NPA to prosecute, because they interfered politically with prosecution. So it's either the failure is the result of internal failures within the NPA, which would relate to things that were done from the time when the cases arrived to the NPA offices, or its external interference whenever it started. The terms of reference say look from 2003. But we all know context in law is king. Context is king. So you'll see the lead up to that. But I was giving you the test and just giving you the problem of the case.
What
in
you
summary.
outline is what I would refer to as a value chain
Yes,
that leads to a particular circumstance.
yes.
Is remoteness a factor within the value chain? Remoteness of the party's involvement or role within the value chain. Is it a factor?
Yes. So I have, my lady has called it a value chain. You could also call it a causal chain, that you have the commission because of the failures. The remoteness would not be a matter of time, so you don't say she was in the institutions about 30 years ago, which is the argument we made. It's so many years ago.
Subject matter remoteness.
Yes.
Because
It might in determining whether the subject matter of the litigation truly arises. In other words, asking yourself, it may be a factual cause, is it a legal cause? And that was where remoteness will feature if you're testing legal cause, because you're looking whether it's the proximate cause or the test for legal cause. But we submit with respect that, and the one test I should refer the court to is what was emphasized in the Dube judgment, that you are involved in a normative value judgment, in forming a normative value judgment. So what the court is asking me is for a clinical assessment of legal causality to determine whether in fact this circumstance may give rise to a reasonable apprehension of bias. Recall that the reasonable person you posit is not you and I who are sitting in court and read the law reports and the like. It's ordinary women, men, or it's wrong to be binary. The correct terminology escapes me, but the construct of the reasonable person is a normative construct. Is not an intelligent person, well-read, and the like. So it's not, when you're looking at reasonable apprehension of bias, you're not looking at that sort of test. A clinical evaluation, does this cause that in law?
I'm asking you that because in how your client has phrased his reasonable apprehension, one of the things he says is that Justice Sisi might defend the decisions she made in the roles that she played in the past. So what decision is there to be defended?
Yes. That's
that she made in those roles.
Yes, it is correct that there is that allegation. But recall that when the client pleads the case, they put the facts before the court. The debate on whether the facts meet the legal test is a matter of legal determination. It's not for a client. So my client is, you will not find prior associations in his founding affidavit. You will find logical connection between this and that, or just the factors and saying a reasonable person would have an apprehension, and I have an apprehension that this or that might happen. But what you're required to do is assessing these facts to determine whether they could, in the eyes of a reasonable person, knowing all the facts, raise an apprehension, a reasonable apprehension, that the decision maker might fail to bring an impartial mind to bear. He doesn't have to say that the decision maker is going to be biased against me and give an adverse outcome. The obligation is to bring a mind open to persuasion by argument, by evidence, and your consent with whether the facts rise to that level which can result in an apprehension. Now, the cases I've referred the court to in Safu and APSA, and also APSA versus Arif in the SCA, make the job of the court easier in circumstances where the complaint fits a particular category of conduct. In other words, if the case is about direct financial interest, you would look at the test applies slightly differently, and you see in Bennett, the first part is about that. But if we're dealing with prior associations, the cases are very clear. Prior association on its own is not a disqualifying factor. But where the cause, the subject matter arises from your prior associations, you must step out, because it's accepted that in those circumstances there's likely to be, it can be accepted that there will be a reasonable apprehension of bias. Alternatively, if you had access to particular facts which bear on the issue before you, you can't be sitting. So if I can just go back to the...
Which factors are those? And that's the difficulty I
No.
have with the basis for this argument, that there's generalizations about subject matter, prior role, but there's no specificity.
Sorry, I might have conflated something here. What I'm submitting to the court is there are two parts to the prior association test, both independent of each other. The first part is, if the subject matter of the inquiry, the investigation as to why there has been a failure to prosecute apartheid-era perpetrators, that's the subject matter. If that subject matter arises from her prior role, if that is connected in that way, in that causal way, and the essence here is that you must be perceived to be independent from the cause of the litigation. You can't be perceived not independent from the cause of the litigation and be the judge or the fact finder. So the first test, which traces from SAFU paragraph 76 and APSA paragraph 78, is simply as simple as that. Does the subject matter of the litigation, of the inquiry in this case, arise from your prior associations? If there's that connection, you can't sit. It doesn't matter whether we can show that you have particular facts that you acquired which bear on the subject matter. That's a separate test. So the association, you're disqualified in the first instance. You could also be disqualified because you had facts, particular facts. And that's why in APSA, those tests are identified separately in paragraph 78. The first paragraph 78 is I read to the court, and that's very, very critical to the case, because once the court doesn't get that, then you will not see how the ruling is irregular, and you will not see why there is a case for recusal here. Paragraph 78 of APSA starts off by saying, prior association with an institution cannot form the basis of a reasonable apprehension of bias unless the subject matter of the litigation in question arises from such associations or activities. That comes from SAFU. That's a self-standing test in SAFU paragraph 76. It's not qualified by the nature of the facts you acquired in that role. It's simply the connection, the causal connection. My lady called it the value chain. Value chain, causal connection, whatever one calls it, logical connection, whatever one calls it, it's the connection. You cannot be perceived to be independent from the cause. The cause arises precisely from your prior association. You refused amnesty. Those people had to be prosecuted. you went to the NPA to prosecute those cases. You were the second in command. Some of the people you refused amnesty are now alleged to be the ones who are interfering and caused the failure to prosecute, firstly. You also have victims before you for family members who were killed, where you refused amnesty and you said those perpetrators must be prosecuted. It beggars belief that in those circumstances, one can say that a reasonable person would not have an apprehension that when I'm President Mbeki and I'm appearing before the Commission and I'm alleged that from 1998 I engaged with apartheid generals to agree a total amnesty in order to avoid the risk of prosecution against the ANC 37 leaders, which include me. So I was engaging in this for self-preservation. And I put a process in place. I initiated this thing in the presentations to Parliament, all of that, and those manifest in actual failures by the NPA to prosecute from 2003 onwards. That when you are now the chair sitting, there are victims before you, families of victims, that you, in respect of whom you said the perpetrators must be prosecuted, and you were in the NPA to prosecute them, and you simultaneously you refuse me amnesty and former President Zuma. We must somehow it is unreasonable, wholly unreasonable, that applying a normative value of an ordinary person in the streets looking up on this would find that this is, I have an apprehension. Assuming this bench was the amnesty committee that made these decisions, and this bench was in the NPA in 1998 and 1999, and this bench must now determine whether my client interfered in the prosecution of the victims who are before you, saying that you must find my client guilty of that interference and recommend prosecution.
I'm tempted to come in at this stage.
Yes, ma'am.
Is it not so that commissions of inquiry are expected to operate within the confines of the commission and the terms of reference?
Yes.
In this case, this is 2003.
Well,
is that not the crux of the issue? So if they were to go back years, long after the first respondent has left, will they not be, you suggested that context is everything, but will that not be outside the mandate? The mandate is that it's from 2003.
So, my lord, you get a case here saying there was a land dispossession in 2003. That's the cause of action. But in the pleadings, they tell you about the history of how this generated in 1998 and that leading to the dispossession. What the proposition that's been suggested by the respondents is that when the court determines whether there was land disposition in 2003, it would be stepping out of its mandate if it seeks to understand the facts, the historical facts that led to that land disposition. That proposition is absurd. Because the point is this, and that it is absurd is apparent from the Rule 33 notices that they've issued. In the case of my client, President Mbeki, they've asked him questions about 1998 and the meetings with the apartheid generals. Those are the allegations in the Rule 33 notice. That he met with this general and that general, Constant Viljoen, and later President Zuma took over and President Viljoen detached. All of these were machinations to come up with a general amnesty for self-preservation. That's not relevant. It doesn't mean that the Commission must say that there was political interference in 1998. That's not what we're saying. What we are submitting to the court is, in order to understand how the political interference came about, it has to understand the historical context. In order to understand why the NPA failed, whether the failure is not internal, it has to understand what institutions, what processes, what policies, what decisions were made by the NPA when it was given this list of cases in 1998 and 1999 and the like. That's why they're called the former chair of the unit which they established to deal with TRC cases in 1998. They're called Justice Saldana, who was the head at the time. He was an attorney. They've asked him, they've asked Advocate Nuka to testify about that context. Mr. Ackerman, Advocate Ackerman, he has already testified about these things and alleged all of this stuff about meetings with the generals. So the point is, and we know that's what our constitutional jurisprudence tell us, that when you are going to determine a right, you determine it in context. When you determine a wrong, you determine it in context. You don't get parachuted to a point in time. There's no freezing in time. This is a continuation, it's a continuum. You started taking the steps and they manifested in interference in 2003. So the only point I'm making with respect is this, that on the association point, all that we need to demonstrate and that the applicants need to demonstrate before the chairperson is that the subject matter of the inquiry arises from the associations, not that the commission will be answering the same questions that she answered in the amnesty committee and in the NPA. And that's the question just Muliba is asking me. What decisions is she required to defend? She's not required to defend decisions. She's required to be seen to be independent, perceived, not just to be perceived reasonably to be independent from the cause of the inquiry and the subject matter of that inquiry.
I am equally tempted, like my brother, to enter the fray with regard to the inquiries that they sought to make with you. You have nicely outlined the text with reference to SAFU and to the ABSA page. Yes, with reference in the quotation very up. But you also said something very important, namely something more, and that comes from SAFU, something more than prior association has to be brought out in an application like this. And I've also, if I heard you well, heard you to be making a concession to the effect that your client, or should I say the clients, the applicants, have found it a bit difficult. I'm paraphrasing what you said, you correct me if I'm wrong. Find it difficult to make a direct link, both in terms of time and in terms of fact, to the time that the first respondent served in the MPA and also served in the amnesty committee. And I'll try to make an example of it. There's a letter that was written by lawyers, Weber Wenzel, that seems to have led to the clients, and again, you correct me if I'm wrong here, drawing inferences of this more than just prior associations. When they referred to her as having been in the HRIU investigation unit of the NPA, and a fact which in the replies that have gone between the parties has been found to be, and this is the impression I have again, thin on the ground, in the sense that in the HRIU, what did she do if she was a member of that unit in the NPA? What did she do that connects her here? Because, and when I said I understood you to be making a concession, you said something like your client does make generalizations about the fact that respondent had this prior association to the NPA and the Amnesty Committee without coming out with the facts. So there has been no actual link. My sister has also asked the question, which is related to what I'm asking you. What decisions was she called upon to defend, or what decisions, I will add, link to her current role to then lead to a reasonable apprehension of bias? I make the allegation, or rather the suggestion, that I find in the founding affidavit, or is it the answering affidavit? It is both, I suppose, because it's applicant and the respondent. I find the allegations that he makes, that is your client, rather thin in terms of making this connection, other than this broad allegation of events that happened between 2008 and 2001, and his brother and sister alluded to it. The terms of the commission are explicit about 2003. I have listened to explanation about how that doesn't bind the commission because the history has to be outlined as to what happened after 2003. That is true. But then we are slipping back into a situation where we are causing prior association to be the reason for a reasonable, what they call a reasonable apprehension of, and then justify it by saying, well, it's history. We can't get away. It's true. That is correct. It is true. But that history that remains out there, cold. She was a member of the Amnesty Committee, and she was a Deputy National Director of Prosecutions. But, and then what did she do? What did she say that you need to know? Lastly, I want to refer to the terms of reference of the Commission. This is about interference with the prosecutions, or the failure to prosecute, and people who are alleged to have engaged in that prosecution. So how on earth then does that crystallize into a person who would bring decisions where she refused amnesty to people like your client, bring into the interference terms of reference, because that's all. That's all she's going to do, or she's supposed to do, or she's doing, and that has no impact on your clients, in the sense that the commission, as has been described by my brother, is just to advise the president. The person who's going to be taking action about what comes out of this commission is the president, not her. The commission will make a report in July, hopefully, and that will be it. It will be done, and it should be out of office. How does she then prejudice them? Because she's not going to decide issues that would directly impact on people like your client. I think I've said enough, but I hope you get what is worrying me in terms of your client, among others, doing exactly what was warned against in Sarfu and in Bennett. Namely, don't use prior association as yes, we can trust you, we can, even if you've been a judge of the highest court in the land, we can trust your impartiality, just purely because you belong to that history, long time.
Can
Before
I-
you answer, Mr. Manaiti,
Yes.
the engagement we've been having this week had me reflecting on the purpose of the duty upon a judge to disclose. You will recall that in South Africa, Dr. Late actually did not persist with his recusal application against, or rather the appeal thereof, in respect of Judge Khampepe because of the disclosures that he made. And disclosures would serve to allay the apprehension of parties, the public, about the likelihood of the presider being biased. And we are here debating what the parameters are, what did she know, what did she not know, how remotely was she connected to what is now the inquiry, when a simple disclosure could have allayed the apprehension that we are being called upon to determine whether it arises. So it doesn't make sense.
Correction, when I was putting my questions, I think I referred to 2008 when I should have been saying 1998.
I understand. I took it as
Correction.
yes. Can I just start with the last question, because that is a very important question, because both the Constitutional Court and the SCA have emphasized the duty to disclose, and that when there is a duty, especially in this case where there is an allegation of your association, Justice Sparkle says, what did she do in the NPA? Exactly what did she do? The allegation is made and is met with either a denial or before the commission, all the facts are common cause. I'll show you the ruling where she says, paragraph 20, all facts are common cause. What remains is what the implications of those are in law. But now, before this court, you have a denial, a bare denial of what she did when she was in the NPA. Now, in Dube, and I'll refer to Dube because we quoted that in the supplementary heads, at paragraph 13. In the supplementary heads, we deal with at 054-96 with the normative evaluation that is required of a court when determining whether where bias is disputed. First, we refer to the Sakau judgment, which says the Constitutional Court found that in adjudicating a recusal application, the court superimposes a normative assessment on the litigant's anxieties. It attributes to the litigant's apprehension a legal value and thereby decides whether it is such that it should be countenanced in law. In Dube and others, again referred to the normative value, which is in paragraph 9, involves the value judgment of the court applying prevailing morality and common sense. And at paragraph 13 of that judgment, which follows after the judge discusses the bungalow principles, the various approaches in America, and emphasizes the duty of a judge to disclose, that it's a sensitive duty, you must disclose. It says at paragraph 13, the rule is clear. Generally speaking, a judicial officer must not sit in a case where he or she is aware of the existence of a factor which might reasonably give rise to an apprehension of bias. The rationale for the rule is that one cannot be a judge in one's own case. Any doubt must be resolved in favor of recusal. It is imperative that judicial officers be sensitive at all times. They must of their own accord consider if there is anything that could influence them in executing their duties or that could be perceived as bias on their part. It is not possible to define or list factors that may give rise to apprehension of bias. The question of what is proper will depend on the circumstances of each case. So there's a duty, and the disclosure would allay the doubt, would allay the very doubt which that letter, which I will refer to, raised, which the Commission did not dispute, which was repeated in the recusal application by my client, which the answering affidavit deposed by our colleague Sumenya SC repeated, quoted the letter and said nothing about it. And the hearing was held. In the ruling, she said facts are common cause. The only thing she denies is she's not aware of any policy affecting TRC cases that she was involved in. She's not aware of it. She's not disclosing facts. Nothing. We don't know as we speak. We know she was second in command in the NPA. We know that Advocate Nuka from 1998 was preparing for the prosecution of TRC cases. The second in command is quiet about what role she was playing. Completely quiet, other than a denial. Now, what the cases say is you disclose, because when you don't disclose, the question is there something to hide? What is it you're hiding if you don't make full disclosure? You make full disclosure, offer people the opportunity to decide whether you nevertheless have you sit. So I emphasized the point and raised that it is emphasized in both SAFU, in APSA, and in Dube. And these are leading cases of difficult recusal applications of almost the whole Constitutional Court, of the former Chief Justice when he was the JP, and of 2 justices of the SCA. Courts, when determining recusals, must be less than sensitive. They must appreciate that what you are engaged in is a normative assessment which, when improperly assessed, undermines the independence of the judiciary, the public confidence in the judiciary. When you give a result which reflects sensitivities by the bench to confront a situation like this. And with that backdrop, I come back to the questions from Justice Batko. Justice Batko, the question you asked is the cases say something more must be shown and not just prior associations. The cases don't only say that, the cases answer what that something more is. I refer the court to the SAFU judgment, which says the question is not, Justice Batko asked, what is it about her that links her to what she's doing now? It's not about the individual. It's about the subject matter of the inquiry now and what role she played then. Is there a connection in the sense that what she's been asked to investigate now arises from all those prior associations? It's correct that the terms of reference are framed in this way, whether and if there was political interference, whether and if. What you're looking for, what are the causes of the failure to prosecute? It is possible that having listened to Advocate Nuka and all the NPA people, Advocate Nuka, by the way, is on the one side, we quoted him saying there was no interference. And then the others saying the NPA was doing its work well, but there was external interference. So you have diametrically opposed views that are confronting this chairperson who was in the NPA setting up the grounds with them in 98 and 99. That chairperson, with respect, has, at the end of the day, the first question she must determine is, it's common cause there was a failure to prosecute TRC cases. What is the cause of that? Is it political interference? Is it internal failures? Because in order to arrive at the conclusion that it was political interference, she has to exclude other potential causes of that, or as proximate causes, as legal causes, as I was asked.
Yes. Without interrupting you, yes. I see you referred to personalities, NPA personalities, if I can call them that, testify. I noted that you haven't mentioned Bikoli.
Oh yes, I don't think he has testified yet. I may be wrong. Oh, he has. No, I've not been following. Yes, yes, yes. But
and you be aware of case law.
Yes.
Involving your client, and So I thought you would mention him also.
Well, I mean, those cases were decided without my client's involvement. If my lord is referring to those, they were debated in the High Court in the intervention application.
Yes, no. I'm not raising an issue.
Yes.
I was just saying, Mr. Mahendi,
not aware.
not mentioning
No.
another prominent player.
Yes, I can't list, by all means, list everybody who's testified before the commission, and I'm not pretending to do that.
Yeah.
What I'm highlighting is that it are the subject matters, not so much the personalities. So I'm saying you can very much say there is a view that there was no interference from people coming from the NPA. And there's a view that there was political interference. And that's the reason for the failure to prosecute. That means the failure to prosecute is not the result of any internal failures as the proximate cause, as the real cause.
What's the goings on in the commission is not before us. Some of what's happening, what you're alluding to, is not.
No. The testimony of the statement of Advocate Nunca, Advocate Ackerman, and Justice Saldana are all part of this record.
Okay.
Which we were told not to read in full. Remember?
I don't recall who told it.
There's part A, there's part B.
Okay, I don't know.
Is that except if it's referred to?
Yeah, except if it's referred to. We refer to in our heads. We specifically refer to that in our heads. In fact, we are criticized as listing a whole lot of unconnected facts. But we do list those facts with respect. And if the court wants me to just give it reference, we do.
When were your heads filed?
We were the first to file by mistake.
Sorry, on the 30th.
No, with respect, no, Justice Mudiba. We will labored under the... No, but can I be listened to? It's a simple point, not the controversial debate here. We labored under the impression that the course directive had not been changed. So before 12 o'clock on Monday, the 9th, we filed our full heads. On the 13th, which was the correct due date, we filed supplementary heads because we had worked under extreme pressure.
And you asked to be condoned.
No, why be condoned? That was the due date.
Yes, I'm saying that you overlooked the fact that there was they were changed.
I can't be condoned for coming early.
All I'm saying is that there were changes to the directive that was issued earlier.
Yes, but that we complied earlier doesn't need condonation. Yes. But we complied in all respects in the filing of heads, and in those heads, we referred to that evidence that was left there, and we, with respect, if the court looks at 054-35 in our heads of argument, under direct knowledge, we deal with the evidence of regarding the TRC, that's the evidence of Justice Saldana. We refer to the evidence of Advocate Bekoli. Oh, actually, we actually do, We have, in the heads we have Ackerman, we have Bekoli. We are very fair. And we have referred to Advocate Nuka, and we have referred to Ackerman. We've referred to all of them.
No, fair enough.
Yes.
We're running late. We're running behind time.
Yes, with respect, yes. But it's not an easy case.
No, it's not.
Yes.
I'm not about to suggest otherwise.
Yes.
All
So,
I'm pointing is the time question.
yes, I understand. I think we're reaching adjournment, which means we will have to proceed tomorrow morning, and I will beg the indulgence of the court to give me just an extra time to demonstrate by reference to the ruling where we say the ruling falls short of the test. But I must answer Justice Bakos. So I was saying that something more is answered in that test. The something more is that the subject matter of the inquiry must arise from the prior association. That's the something more. So it's not, I may have an association with Absa Bank, as in this case, but if the claim has nothing to do with my prior association, there is no causal connection, then it is an irrelevant association. So with respect, this is not an irrelevant association. This is an association that falls within that test. Because there's no way of thinking away the fact that the subject matter of this inquiry is to investigate the common cause, failure, and why is the failure? Whether and if it was the result of political interference. If so, by whom, when, etc. And that you wouldn't have that inquiry at all if you had not had decisions to refuse amnesty, and that those refused must be prosecuted, and the NPA taking steps to prosecute and not prosecuting. You wouldn't have this inquiry. It wouldn't have arisen. So there is a, and it's a common sense, is a legal, it may, there may be debates about legal 76 of SAFU, paragraph 78 of APSA. They answer that question. And that's why in the APSA case, in the Constitutional Court, they said there was no link drawn between the associations in the banking institute and the claim before the court. There's no link.
Just one little bit to throw in. I'm sure your concern about time, the presiding judge will give concern to that.
Yes.
And the question is, how much is this court supposed to take into account the views of some of the respondents that the Talaka group, to the extent that they are saying they are opposing, they're opposing this application by the applicants, and they are a group that's quite significant, if I can just put it that way, in the whole inquiry that's going on. Of course, having brought about the formation of this very commission and so on and so forth. How much does one, is the court supposed to take into account that they are opposed to the application to recuse the chairperson?
Yes. Well, on the recusal test, the test is normative, is objective. Their subjective views don't sway the test one way or other. But they will make submissions on why the objective test is not met. You'll take that into account. They're a party before you. But as to their personal views about whether she can or can't be impartial, that's irrelevant. That's not what you're looking at. That's why even the personal views of my client are not sufficient unless they rise to that normative value that you can give them legal value that, yes, a reasonable person in this circumstance can entertain this. But you will see that even they kind of blow hot and cold. They started off raising the issue that there may be an issue with the chair, which some other people may have discomfort that she mustn't be the right person. She's not the right person to sit. The failure that happened is that the chair didn't there and then say, hang on, clear the air. Here's full disclosure. This is what I did from 1998 to 1999 in the NPA. Because she's wrong to say that what she did in the NPA is a matter of public record. It's not. It's what she did in the TRC, which is a matter of public record, because you can go to the website of the TRC and find the rulings she made. But in the NPA, you won't find the advice she gave to Advocate Nuka on the prosecution of TRC cases. You can't get that. So it's knowledge that only she has. And she doesn't come out and make a full disclosure. It could have resulted in the same outcome in relation to Justice Krippler. The second point I need to respond to is the idea that there are generalizations in the affidavits, and I'm going to take the court to the paragraphs. There are no generalizations. As to the TRC cases, there are the particulars. You made decisions in the ANC 37. You were part of the decision making, refusing the amnesty. And I'm now accused of interfering. I'm appearing before you. That's specific. You also made decisions in relation to 3 or 4, whatever number of families. The president has a larger number who are appearing before you. That's fact. That's common cause. So and then she was part of the amnesty committee, which said to the NPA, these cases must be prosecuted. That's common cause. It's a fact. It is also a fact that she was then in the NPA 98. That was when they were receiving this list. She was there. And we say the allegation was not only that she was in the HRU, but that she advised. The denial you have is the denial of I was not in the HRU, I was not involved with the HRU. You get no word about whether in those over a year did you advise Advocate Nuka about the prosecution of TRC cases. No, quite. She's a lawyer. She's there as a lawyer. She's the second in command. He was busy setting up all of this, and surprise, surprise, she wasn't there, or doesn't tell us. That is the fundamental problem, is a failure of the duty to disclose. And it's even telling when you see the criticism of the Commission against the President by Kalata and the Commission. They say the President should have informed himself. The duty is on the person presiding to disclose. It doesn't mean that when litigants have failed to dig up and they come only with the tip of the iceberg, that you can hide the rest of the iceberg underwater because you don't disclose. That's wrong. That's not what this judgment, Sarfu, Absa, Dube, all of them tell us we must disclose. The letter yes, the denial that she was in the HRU is only now in the High Court. Let me just take you to the ruling, because I'll feel it might look like I'm unfair to in respect of the ruling, and I will show you the allegations. So the recordal of the common cause facts is paragraph 20, and that is page 001-43. She says, 20. Further, the evidence leaders have been appointed by me as part of this commission, and I deem it necessary to take their contentions into account. It is to be noted that in the overlapping grounds in the recusal applications, the historical facts of my prior institutional roles are largely common cause, and the resolution of these matters tends primarily on legal argument rather than on contested evidence. Part of that, those allegations were advising the NDPP and advising through the HRU.
Are you reading from the ruling?
Yes, I'm reading from that paragraph 20 was from the ruling. But the matters are largely common cause. The only thing that she places in dispute is paragraph 50, is 001-51. She says, former President Mbeki alleges that during my time at the TRC, I had institutional responsibility for shaping policy on TRC cases. I'm not aware of any specific policy on TRC cases that I was involved in emerging from the Human Rights Investigation Unit during 98-99. As the Kalata Group further points out, this is mere speculation. The averment is not supported by any factual basis. It therefore veered into the realm of conjecture. Now, she doesn't, even today, doesn't take the court into her confidence, didn't take her colleagues on the commission into her confidence about what precisely she was doing in the NPA related to TRC cases in 98 and 99. The HRU unit is one part, and the allegation was...
I just wanted to cotton on to your quotation, last quotation.
Yes.
When you refer to a person shaping policy of the Amnesty Committee and ending there, which is what I suppose to be.
No, that's she's quoting. That's not the full allegation. She's quoting part of the allegation about her role.
Yeah. So when you say a person shape policy, that's the kind of generalization I was kind of talking about. You're not coming out to say the policy that refers to this aspect of the committee and so on and so forth. I just quoted it because that's where my reference about generalization.
But the rhetorical question, Justice Bakwa, is what must my client do? Go open the drawers at the NPA and find out what she was doing. She is the judge here. She is the presiding officer. When she says I'm not aware of a specific policy. What is she aware of relating TRC cases that she did at the NPA? Why can't she just take everybody into full confidence, make full disclosure of it? That might have resulted in the application being withdrawn, like as it did with Justice Sisi, assuming.
What worries me about that suggestion or submission is the question of shifting the onus. Making an allegation and saying, you prove it. He who alleges must prove. If you allege certain things about the person in pursuing your application, you must bring the facts. You mustn't say, I've said you shaped policy. Tell me what policy. That's rather too easy in proving your case. To shift the onus onto the other side and say, you haven't said anything. If you want to make a case against the person, then you must bring the facts.
Justice Batko, if the justices of the SCA had said, if you want to know whether I was in an institute at ABSA, at UJ, paid for by ABSA, go and find my salary slip and find the details and bring them here. That's not what the judges did. They called the attorneys to chambers and made a full disclosure. That's the whole point. The same could have happened with the judges of the Constitutional Court. That's where the duty starts.
Yes, but every case can be distinguished. There are similarities which you have drawn, and you and your colleagues have drawn very accurately and honestly. But if at all you're suggesting the ABSA case should be dealt with, even factually, exactly on the same line, that doesn't happen.
I'm not suggesting that with respect. I'm repeating the general principle of the duty on the judge to disclose. And I can show you another instance of the failure to disclose in the same ruling, and I'll take the paragraph. I don't have the paragraph now. The allegation was you made decisions to refuse amnesty applications in respect of the credit pool or who are part of the Galata applicants. So they mentioned the specific group. In the ruling, all she says is, you are wrong. I didn't deal with those cases. The allegation was you made decisions to refuse amnesty, and that was given as an example. The answer was, I didn't do those, full stop. And then now, in this court, given what the ruling said, then the lawyers went to check and found that actually she made other rulings in respect of victims whose families appear before her. So the allegation about you made decisions about victims whose families are before you was factually correct. But instead of clearing the air and making full disclosure, a la those Constitutional Court judges who presented statement of facts to their colleagues, instead of doing that, she chose to nitpick what was incorrect in the allegation and deny that and full stop. That only aggravates the apprehension. It doesn't lessen it. And that is what Dube says, is if there is doubt, step out. Unless you can make full disclosure, and that is acceptable. But there is a classic characteristic failure, and I'm saying this with great respect. It mustn't be taken that I'm a lawyer, I'm only hired to make submissions. I'm not expressing personal opinions. This is a classic case of a failure of a duty to disclose at various opportunities. First, the letter from the Galata Group in 11 November 2025. That's the first one. There was a letter regarding Advocate Sminya's evidence leader from the same group. She responded to, the commission responded to this one about her own role, no response, zilch, two, right? Then there is the Zuma correspondence on the 3rd of December saying, I would like you to recuse yourself because of your prior roles. She doesn't even say, you're not the first one, the Galata people have raised it. Here are the facts. She says, bring it on, here's a timetable. Come, let's fight. That's the first one. The second one is that in the recusal applications themselves, that allegation is repeated, and the answer of the commission, deposed to by Advocate Semenya, repeats the allegation and says nothing about it. Belatedly, in the ruling, you're told everything is common cause, except that I don't know which specific policy you're talking about. That's all. Now we come before then comes the High Court review. More cases are put up of her role in the amnesty committee, of people who are appearing before her, and the allegation is repeated about her role in the unit and advice to Advocate Nuka about TRC cases. You have a half denial, and I say half because it denies the role in the HR unit. It says nothing about advising Advocate Nuka about TRC cases, how to handle TRC cases. Nothing is said. So you don't have full disclosure. When we sent here, this court and us are in the dark about what her full role was in relation to TRC cases in the NPA from 1998-99. So with respect, we submit that that is a factor, a weighty factor, which aggravates an apprehension than lessening it. It adds to the smell. It doesn't take the smell away. And that is the fundamental problem with how the chair approached this. It could be that she's got perfect answers for this, but there is no answer to allay the apprehension. And both the Salfu and Dube emphasize that you can't leave the doubt lingering and continue sitting, because you are undermining public confidence in the process of that commission. She also did not, the president says in his affidavit, she didn't disclose to him. They say, well, you should have gone to the internet to find this news. But as we submit, on the internet you don't find her office at the NPA and what was happening in that office, what she was doing in relation to TRC cases. You can search the internet. So the internet only goes as far as the TRC role. It doesn't say anything about the NPA. So with great respect, this one travels beyond the associations in Salfu and in APSA, because there's no avoiding the fact that we have this commission of inquiry because of a failure to prosecute. Somebody who was part of the initial stages of dealing with those TRC cases in the NPA is the presiding officer in relation to perpetrators that she refused amnesty and having families, those families of victims before her. And we're looking at a reasonably informed person, the men, women, and the other descriptions in the street, not as sophisticated, looking between the lines and underlining and crossing out, dotting the T's and crossing the I. I think you cross the T's and dot the I's.
Mr. Manager, I have to be sensitive to the following fact.
Yes.
I've got support staff who rely on public transport.
Yes.
They don't have vehicles to leave the post.
I accept.
You and I perhaps are in a very privileged position.
That is correct.
So you suggested earlier that you might want a bit of time tomorrow morning.
Yes.
Housekeeping matters now. How much time do you require to wrap up?
So I can finish my topic in 20 minutes.
20 minutes.
20 minutes, and then my learned colleague will take another 20 minutes.
Okay, now almost what? Almost 45.
Perhaps I should say 30 minutes. If the court will be generous, 30 minutes. I don't want to be asking for a little bit more.
Well,
30 minutes.
I'm sure we can deal with that. Tomorrow we're starting early in any event.
Yes, that's the court.
All right. Is there anything else other than that?
Other than that, no. I'm only indebted to the court.
Mr. Manager, there's an issue I asked Mr. Bofu and it's still bothers me. So I'd like you to reflect on it and address it tomorrow. The grounds of review that both applicants
Yes, the composition.
That is the composition. If you can guide us on how do we remedy if we find that the composition was irregular, and the effect of that is that the ruling made is invalid. How is that remedied?
We can think about it further.
Yeah.
So there are two possibilities. You can refer it back, or you can substitute the decision of the decision maker, because all the facts are before you on whether she should have recused herself. And on the substantive determination, that's precisely what we're going to ask you to do, is that she applied the test incorrectly on the facts, it's reviewable, she should have recused herself.
In respect of those, we are saying we should substitute.
So we're
Step
asking,
into the shoes of the decision maker.
yes, we're asking you to find that she should have recused herself. That's why we asked for the removal. But the appointment by the president is a different issue. But yes, we're not asking to be sent back to her. It's unlikely that she'll make a different determination. There's a history of two rulings. There's not going to be a...
Except that you'll be going back to the full commission, not to her.
Well, my learned friend, Mr. Nuka, I told you, he hasn't addressed you yet. He might say he didn't need the full commission. He might say you must go back to Justice Khampepe.
Alone.
With that said, I'm sure it's time to adjourn until tomorrow morning at the agreed hour, which is 9:30 tomorrow.
Yes, good.
Huh?